Oh, yeah.
I have no idea. Okay. Yeah, he's got some good right.
All right, Mr. Switek.
Morning, Your Honor.
Good morning, Mr. Switek.
Mr. McCoy. Your Honor, this is Jonathan McCoy in 24 CF 1022. We've got a negotiated plea offer to tender. Looked at the score sheet. I don't have any objection. May I approach?
Granted.
Your Honor, in case 24 CF 1022, Mr. McCoy is going to withdraw his previously entered plea of not guilty and plead no contest as charged, to wit, 3 counts of battery on a Leo, resisting an officer without violence, and misdemeanor battery. He agrees to be sentenced to 36 months probation, all counts to run concurrent, all sentences to run concurrent, $967 in court costs. He'll have to perform 24 hours of community service, no contact with the victims, and he'll have to successfully complete the batteries intervention program. He would be adjudicated guilty of all counts.
Madam Clerk, those fees and costs correct?
Yes, sir.
All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
And you put your hand down. You heard what Mr. Switek said, and you signed the written plea form that he's given to me?
Yes, Your Honor.
How old are you and how far did you go in school?
33, bachelor's degree.
You able to read and understand the plea form?
Yes, Your Honor.
Did you do that before you signed it?
Yes, Your Honor.
And is what you read in the plea form what Mr. Switek just announced to me?
Yes, Your Honor.
Do you understand by this plea arrangement that you're pleading no contest to the announced charges?
Yes, Your Honor.
And that says to me that you believe the state has the evidence necessary to prove your guilt and you're not going to contest that.
Yes, Your Honor.
Do you understand by making this plea that you're waiving your right to a trial where the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
And in this case, you'll be adjudicated guilty. You'll be on 36 months of probation with the additional, all the standard conditions plus the conditions Mr. Switek announced as special conditions. Do you understand that?
Yes, Your Honor.
Mr. Switek answered all your questions about the plea and how it affects you.
Yes, Your Honor.
And are you satisfied with how Mr. Switek has represented you in this case?
Yes, Your Honor.
Now, Mr. Switek, I want to be sure you're saying that he could do the community service hours in addition to pay his costs. Is that what you're saying?
Yes.
Granted.
Okay.
Thank you very much.
I have to go over there and get printed. No, we're going to check with probation.
Mr. Kelly.
Your Honor, I've got one more case.
Oh, I'm sorry. Which case do you have, Mr. Switek?
Tajay Smith, this is on for status. You may recall this was a case where they were going to pay restitution out of the cash bond. And we've got paperwork to make that happen if I can approach.
Granted. Very good.
Okay, and that's all I have, Your Honor.
Thank you, Mr. Switek. Good day.
Thank you, sir.
Mr. Kelly.
Good morning, Judge Stone.
Good morning.
Before the court in the state of Florida versus Blake, Shadrick, 24 23-2454, if I'm reading that correctly. Mr. Shadrick's before the court, if I could call him up, Your Honor.
Yes, sir.
Mr. Shadrick. Your Honor, Mr. Shadrick's before the court charged with one count of possession of controlled substance and a possession of drug paraphernalia. The state has been kind enough to extend an offer for a pretrial intervention, the conditions of which would require that he successfully complete a drug treatment program, the Chrome program up in Mariana, an inpatient treatment program, pay $615 in court costs and $150 cost of prosecution. I have a signed plea form, if I could pass that before. Judge, I have some paperwork describing the program if the court would like to review it. But
No, sir. So this is a straight PTI. Is that the state's agreement? This is without a plea?
yes, sir.
Okay. All right. Very good. Now, I guess probation, have you reviewed, and you'll need this to sign that and instruct and then file the original paperwork, correct?
Yes, sir, he'll just take it to our office and PTI will
All right.
transfer it.
So the way we'll do this, Mr. Kelly, is we'll set this for another date for status only, so if the paperwork comes back,
Thank
you
you.
know, as the old joke goes, even though we're digital, no job's done till the paperwork's finished. So we'll set this, Madam Clerk, for,
Do you think February 20th is too soon? Next week?
and that's just status. That way, if the paperwork's done, it'll roll off the docket. If it's not, then we'll come back and see if we can figure out where it is.
Yes, sir.
Okay, so we'll set it on status for February 20th. Thank you very much. Check in with probation, sir, and they'll give you instructions and get that paperwork finished.
We'll get it taken care of today, Your Honor.
Okay, thank you very much, Ms. Kelly. Anything else for you?
Yeah, I just wanted to express one thing. First off, our gratitude to the state for considering this. But second off, I discussed with the state that the program itself is 9 months inpatient, but then there's a transitional period where they're staying there and working back out on the community. That is somewhere between 3 and 6 months long, so it might extend past the 12 months of the PTI. I've been told that the prosecutor didn't feel that would be a problem, you know, that the agreement would allow us to extend it a little bit longer if need be.
We have done that in the past. All you need to do is then the two of you send me a notice with your signature asking that the termination date of the PTI be extended. The goal, of course, since your client is asking for help, is to provide the help that's necessary and allow him to successfully complete the program. I've done that in the past. All that requires is the two of you to sign that, and then I'll sign off as well.
Thank you, Your Honor.
Thank you. Thank you.
There's a provision in the back of the agreement that says we can extend it 365 days for another year if we need to, so.
Okay.
But
All right, very good. Thank you. Thank you, Mr. Kelly. Mr. Durrell?
Morning, Your Honor.
Good morning, Mr. Durrell.
Your Honor, this is actually a bit of an interesting situation. I was checking and saw my name on the docket under Mr. Peets. I actually have not been retained on this violation of probation. I don't believe I filed a notice of appearance in this case for this violation, but I wanted to show up because my name was on the docket. Now, I have spoken to Mr. Gomez, and I believe.
Judge, I think the state will have an announcement that will kind of streamline this. The new law violation, that was the basis for this VOP with Mr. Peets, was dismissed. So at this time, the state would be announcing a dismissal of the violation of probation in 23 CF 2683, and he would reinstate probation to complete his original terms.
All right, so the VOP is dismissed. It looks like, Mr. Durrell, just looking at the progress docket, that you were counsel of record before, and so when the VOP was filed, you were simply notified because you were previously counsel of record. That's what occurred, and I appreciate you being here. That's typical of your diligence and observation of your obligations to the court. So,
Thank you, Your Honor.
but with the announced by the state, the VOP is dismissed.
The state just dismissed your VOP, you're being
Now,
reinstated.
with him, he remains on probation. He'll be restored to probation with all same terms and conditions. Is that correct?
That's correct. So
Okay.
when he gets out, he needs to immediately go see
All right.
probation.
So your VOP is dismissed, so you need to report to probation. They're going to give you a piece of paper as you walk back to holding. Be sure to report to them immediately upon your release, okay?
Yes, sir. Thank you.
All right, thank you now. Good day.
I believe that's all I have, Your Honor.
Thank you, Mr. Durrell. Good
Thank you.
day. Mr. Lupella.
Good morning, Sean LaPella for the record. I have two cases on the docket. I'd like to approach on the first, which is Nesmira Herring with Mr. Snell.
All right, you may approach.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law.
I have on the docket is Simon Vivian Ward, 23 CF 1039, on a motion to expunge his record. And I understand this, I've spoken with the state, and I believe he wants to approach and discuss some issues facing his office. Mr. Snell? There he is.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that
If you just have a seat, we'll be back with you in just a minute, okay? Next, we're going to chat with the folks who don't have an attorney at this time. Everybody's entitled to an attorney. Oh, I'm sorry, I didn't see you there.
Thank you, Your Honor. Jack Wilkins for Sarah Newton. I apologize for missing your collection of names on.
That's okay, Mr. Wilkins.
Your Honor, I don't believe we've continued Ms. Newton's case before. She was, I believe, first informed on January 13th of this year, and I'm still waiting on a little bit of discovery, some video from the state. I don't know that the state has acquired it from Cash's Lounge.
Okay. I think you've already moved off of the docket onto the May docket as a result of your not guilty plea. You were actually on the plea day docket, on the arraignment docket.
Better be earlier, I guess, than late?
Yes, I suppose. And so you're set on, what date is it, Madam Clerk?
May 12th.
May 12th, because, and I know we rotated divisions. My policy in the division is if you file the not guilty, then you're not required to be here at arraignment. I know other judges have a different approach to that, but if you file the not guilty. Now, if you think you can resolve the case sooner, I'll be happy to move it up to the next date, which is 3/10, if you believe you can be here sooner and possibly resolve the case.
I'll be speaking with Mr. Gomez as soon as he's available concerning Ms. Newton's case.
All right, so you're going to hang then for a little bit and let us know? And
Well, if we could, just keep the May docket. That'll give me a little bit more time with Mr. Gomez and getting that discovery
okay.
video.
Right. So we'll leave it on for May. Thank you very much.
Thank you, sir. May be excused.
Yes.
Have a pleasant weekend.
Yes.
Judge, I've got Mr. Gamble, bond hearings. Judge, he's got 3 cases on the docket, 22 CF 181, 22 CF 2532, and 22 CF 2632. Judge, in 181, his bond is $3,500. In the 2532 case, his total bond would be $125,000. And then in the last case, it's looks like $122,500. Judge, these cases have been going since 22. Interestingly enough, the 22 CF 2632 actually had started out as a 2021 case, 2021 CF 1295. They had a date set for trial. Everybody was here to pick a jury, and the state suddenly announced a no pros, only to turn around and refile on it the following, I think, February, if I remember right. Mr. Gamble's cannot make the bonds that are set. It's, from everything I can see, I don't believe that he's ever had a prior failure to appear, but he's asking the court to modify his bonds to something that's basically affordable.
All right, what's the state's position on the request?
Your Honor, the state's position on the request is that we would respectfully request that this motion for bond reduction be denied. We have previously been here on a motion for bond reduction, I think the last time. And there has been, based on what I've heard, there's been no material change in circumstances to warrant any sort of reduction of bond from the last motion for reduction of bond that we've had. And looking at Florida statutes 903-046, which is the purpose and criteria for bail determination or bond determination, we have the nature and circumstances of the offense charged, the weight of the evidence against the defendant, family ties, length of residence in the community, defendant's past and present conduct. With respect to the nature and the circumstances of the offense charged, if you look at the statutes that we've charged the defendant with, namely the trafficking in fentanyl, and the three trafficking counts across those three cases, this bond is actually lower than most of the bonds that we've been giving, especially as of late and requesting because of the fentanyl issue, and particularly in this area. A $50,000 bond, hold on, let me make sure I've stated that correctly. A $75,000 bond for trafficking in fentanyl is more than reasonable given the charges, and in particular in that, and then on the 2532 case, we have a $50,000 bond for trafficking in fentanyl. So the state feels as though those bonds are extremely reasonable given the severity of the charges. In the 2532 case, there's a substantial amount of fentanyl that is found in the car that was solely occupied by Mr. Gamble. It was found on top of some identifying documents of Mr. Gamble's, along with receipts from very recent days that shows Mr. Gamble's payments for various things. So it's very clear that he is the possessor and the controller of the vehicle and the things that are in that vehicle. In the 2632 case, law enforcement officers actually attempt to stop Mr. Gamble. He flees, actually ends up getting out of the vehicle while it was still going. They see him with a black bag. He tosses the black bag. They find the black bag, and the black bag has fentanyl, sale, manufacture, and delivery weights of other substances such as methamphetamine and cocaine. Your Honor, simply put, we feel as though these are extremely reasonable bonds for the charges as they are charged. We do feel as though the evidence is pretty high and is very weighty against Mr. Gamble. I understand and appreciate Mr. Gamble's concern for how long this has taken, but you know, since the last motion for bond reduction, we had a motion to suppress. We've given other offers since that time, since that bond was given on January 18th, or the last bond hearing was set on January 18th of 2024. And we are tracking towards a trial in this next cycle. Given all of that, Your Honor, the state respectfully requests that this motion for bond reduction be denied.
Mr. Nopes, do you wish to put any evidence on the record regarding the criteria under 903-046?
Judge, I really, Mr. Gamble just wants to speak, if that's all right, Judge.
Yes, sir. Have you advised him to restrict his comments to the issue of bond and not to address the factual circumstances unless they address the bond, so to be certain he does not incriminate himself?
Yes, sir.
Are you confident that he'll take your advice in that regard?
Judge, I believe he will.
Okay.
So the only thing I want to say, I've been locked up for 3 years, away from my family. I've been asking for bonds, reasonable bonds. I've been waiting on the state for 3 years, 4 years on 2 of my cases, and it's just not But I don't feel like it's right because I have to wait on him to keep going and going and going and going and going. And I got 6 kids. I have to try to take care of my kids through a jail. And he not ready and don't. We set trial for February 3rd. He wasn't even ready. The only thing I'm asking is, can I get some time to go see my kids and my family instead of through a box that I've been doing for 3 years? That's the only thing I'm asking. And it is not like I'm a threat to society or anything. I just went on a furlough. My granddad just died the year that just passed, and they let me out of jail while I turned myself back in.
Anything else, Mr. Nopes?
No, sir.
The court consider, and we're going to address the issue, I know we're here on the bond motion, and we're set again, Madam Clerk, for 310, is that right?
Yes, sir.
All right. And which one of these cases are we going to try this cycle?
2532, Your Honor. We've actually already sent subs out for, we actually had set, if I'm not mistaken, we had actually set this for 2 dates for trial so that I could send out my subpoenas, if you recall, to the multitude of DEA agents that are on this case. And we've set that for, I believe, March 27th and 28th.
Okay. All right. The court has considered the bond motion, the arguments made. The court has also considered the criteria of 903-046, particularly the issues involved in what the legislature's instructed the court to consider. And one of those considerations is the street value of any drugs or controlled substances connected or involved in the criminal charge. And the statute tells me it's the finding and intent of the legislature that crimes involving drugs and other controlled substances are serious social concern, and that the flight of defendants to avoid prosecution is of a serious similar social concern, and that frequently such defendants are able to post monetary bonds using the proceeds of their unlawful enterprises to defeat the social utility of pretrial bail. Considering that I wasn't supervising this case in the beginning, considering that looking at the bonds, considering the circumstances presented in the case, particularly in just one case, we have a total of 31.5 grams of fentanyl, 60 grams of methamphetamine, 27 grams of cocaine, and that's just in the one case. The court finds that the bonds set in this matter are reasonable to assure the defendant's appearance at trial and to protect the public, and the court will not modify the bonds in this case. The case is going to trial. The one case is going to trial, so we're going to dispose of that one way or the other in this trial cycle.
Thank you, Your Honor.
Thank you.
I'll see you this weekend.
All right, so once again, back to the folks that do not have a lawyer. Everyone's entitled to have a lawyer represent them. If you're not able to afford a lawyer, then the Florida Constitution and the federal Constitution provide that you must be provided a lawyer at the state's expense. To do so, you're required to complete an application for the appointment of that lawyer. The application is a goofy government form is the best way I can explain it. If I haven't been doing this for a couple of decades, I probably would sort of look at it the way I do at my tax form every year. So what I ask is if you're interested in the appointment of a lawyer that you complete the form here today. I look at it and check the areas where there are common mistakes simply because the form is hard to understand. I'll call you up one at a time. If you wish to have a lawyer, then I'll ask you to complete the form. Turn the form in. Don't leave until you turn your form in and you get a new court date. However, the state may have an offer for you to resolve your case. If you feel comfortable that you're able to accept that offer without the assistance of a lawyer, you're free to do that. Now, I can answer questions about what the state's offer is to explain to you how that might work or what it means. I can't answer questions about how will this affect me? What will this have an effect on this or that or that? Those are questions for a lawyer. If you have those sorts of questions about what the state's offer is, then you would need to consult with a lawyer to have those questions answered. Alexis Morales, please come forward. All right, good morning.
Good morning.
You're here today without a lawyer. Would you like to have a lawyer represent you, or would you like to hear what the state has to say first?
I hear what the state's got to say first.
What's the last name? I'm sorry, Your Honor.
Morales. It's 24 CF 615.
Sorry, Your Honor, I'm pulling up the plea offer now. It would be admit the violation of probation. We would offer, it'd be kind of two offers. If you wanted to revoke in term and be done with probation, we would offer 6 months in the Okaloosa County Jail. If he wants to remain on probation, we would do a withhold or maintain a withhold, modified probation to add a substance abuse evaluation and a treatment recommended. Wait, no, I'm sorry. To add a year of community control, Your Honor.
All right, so do you understand the state's offer? There are two separate things. If you admit the violation, then they terminate and sentence you to jail for the 6 months, or if you admit the violation, then they restore you to probation with the additional conditions, including the 1 year of community control. Do you feel comfortable accepting that, or do you want to talk to a lawyer about it?
I'll talk to a lawyer about it.
Okay. All right. A form will be given to you. Complete the form, pass it back to the bailiff. Don't leave until you turn the form in and get a new court date, okay?
Yeah, okay. I think
Irvin Willis, please. Good morning, Irvin Willis.
Good morning.
You're here today without a lawyer. Would you like a lawyer, or like to hear what the state has to say first?
I would love to hear what the state has to say.
All right, State, Irving Willis.
May we approach the defendant and I?
Yes.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Probation?
Yes, sir.
The court's made a determination based upon the state's acceptance of the defendant's proffer. The defendant doesn't have the present ability to pay, so he'll be permitted to terminate with this outstanding condition since his other conditions have been met. Okay? All right. Thank you very much. And at the end of that, the outstanding cost and restitution will go to a lien. All right. Thank you.
Judge, may I call somebody in the gallery who is not on the docket?
Yes, sir. Who might that be, Mr.?
Reginald Carter and Reginald Castor? Yes, sir.
And you have a case number for me, Mr. McKinney?
22 CF 2815.
2815?
Correct.
Okay.
And when Your Honor looks that up, it's going to show a court date in front of Judge Clark on the 18th. And it's also going to show an order to appear for the violation of probation for today's date. So Mr. Castor came today because
Yes, indeed. Yes, indeed it does.
So he did not want to miss court, and he came over from Panama City. He was in the courtroom. I wanted to address it as a friend of the court.
And of course, probation is not going to be able to be prepared.
I believe he does have some certificates of completion. This looks like a violation of probation, that he may be able to show probation while he's here.
Yes, and what I would say is that I'm going to send a message to Judge Clark's JA and let him, after he shows this to probation, go to Judge Clark's office. And if Judge Clark agrees, then I'll handle the case today to save him the trip, but I would require her consent to do so.
Yes, Your Honor. So if you want to take a seat for just a moment. Judge.
But share your documents with probation now so that they'll be able to make their notes. And then after that, you can travel to Judge Clark's JA, and she'll inform me if Judge Clark consents for me to dispose of the matter on her behalf today, okay?
Sure,
Thank you, Mr. McKinney.
Thank you, Judge.
Your Honor, I have an interpreter in the gallery.
Hey, give me just a second, Mr. Klein.
Yes, sir.
I'm sorry, Mr. Kleins, go ahead. All right, Madam Interpreter. And what are we doing today, Mr. Kleins?
Your Honor, this is a capital sexual battery case right now. The state has made Mr. Victoriano an offer, and I believe the state just wants to put that on the record.
All right, Madam Interpreter, raise your right hand. Do you swear to interpret these proceedings truthfully, adding nothing and subtracting nothing?
I do.
Your Honor, Mr. Lamone Victoriano is present.
Sure. State's offer would be plea to lewd and lascivious conduct. There'd be an adjudication of guilt, court costs, 10 years of sex offender probation. He would be designated as a sexual offender. He would have no contact with the victim or minors. He would be attached to a GPS before his release. State would have no objection to $1 per day. And all the other requirements of sex offender probation.
And, Your Honor, I did get a chance to talk with Mr. Lamone Victoriano at the jail this past Tuesday, the 11th. I relayed the state's offer. We talked about potential counteroffers. He is aware that this is a capital case and that if he proceeds to trial, he's looking at a potential life sentence. Given the fact that he just learned about this less than 48 hours ago, I would ask the court to leave this case on the March 10th docket. I cannot definitively state that this will be set for trial that cycle, but if it's not, it will be set for trial in the month of May if there is no disposition this coming month.
All right.
I'll come talk to you at the jail.
Okay.
Okay. That's it, Your Honor.
Do you need another minute with him with the interpreter?
No, I spoke with him for probably half an hour on Tuesday. And my intention is to go back to the jail before March 10th with another interpreter to meet as long as he wants. This is the first time that an offer's been made in this case.
Okay. Do you understand the offer that's been made?
Yes.
You understand your lawyer's going to come to the jail and speak to you about this?
Yes.
Is it the state's intent to leave the offer open until docket day of the next trial cycle?
It is, Judge.
Your lawyer will explain to you that once the case is set for trial, I'll accept no offer after docket day when the case is set for trial. He'll explain to you what that means, but essentially there will be a final date in which you'll be permitted to accept an agreed upon offer. Otherwise, the only plea that I will accept once the case is set for trial is a guilty plea as charged.
Okay.
I simply like to explain that to everyone so that they're aware and not surprised when that happens.
We'll talk about it. Okay?
All right. Thank you now. Good day.
Thank you so much.
I'll see you in like 2 weeks. Dos semanas. Okay?
All right. Ms. Mr. Klein, you ready with the balance of your folks?
Do you want me to call the ones that are in the gallery right now?
Yes, sir. That would be best. Let's clear them out and get them on their way.
Your Honor, I have Herman Beck.
Herman Beck, please.
This is Mr. Beck, Your Honor. We are in hopefully successful plea negotiations, but we would ask the court to pass this over to next Thursday, the 20th. I have provided the state a number of mitigating documents and reciprocal discovery. I just received another document this morning. Hopefully we can get this resolved next Thursday. I don't want to just kick this to April if we can potentially get it resolved next Thursday. So if the court would allow us to put this on for next Thursday without subpoenas.
State?
No objection, Your Honor.
All right, it'll be moved to the 20th.
I'll talk to you before. Okay. All right. Yep. I think that's all I have in the gallery right now, Your Honor. Do you want to pass it to Mr. Koch?
Mr. Koch, you have any folks in the gallery we can dispose of?
Yes, good morning, Judge.
Good morning, Mr. Koch.
Judge, I'd first like to call Mr. Joshua Rogers, who's present and approaching. This is 22 CF 1852. Judge, ultimately, I'm asking for a continuance. Unfortunately, my client failed to appear for our February 11th telephone conference we had scheduled. Also, I still need an offer for Mr. Snell, so I'm asking to get this placed on our next VOP docket, Judge. For
Mr. Snell, does the state have an offer in this case?
It would be incarceration.
For life? For a day? What's the offer?
The allegation is it would the facts of the case are not good, and there's serious injury involved, so this would be a situation where we'd be off asking for Department of Correction time.
All right, so but you don't have a specific offer that you're prepared to make other than as a guideline sentence? What is the guidelines? Give the court some ideas here.
May I approach?
Yes, sir.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
All right. So we've set the case for trial. It's actually a hearing on the VOP, and it's going to be set on the 17th. Now, your lawyer has to have access to you. He's got to be able to talk to you in order to be prepared for trial. So the case is going to be set for trial on the 17th of April at 1:30. So be prepared and go forward. The court's not going to continue the case. Although it's been pending only a short time, well, actually 2 months now, by then it's going to be pending, longer than I like to see them pending on a VOP. So I'm not going to continue the case.
I understand.
He has to have access to you to try the case. All right?
Yes, sir.
Would you like it to be set at 2:30?
Yeah, let's set it at 2:30. That's right, because that's Thursday. At 2:30. I'm sorry, Mr. Koch, because we also have pretrial detentions that day.
Yes, Your Honor. And you can call today. Yeah, let's get it over. Okay? Absolutely.
Thank you, Madam Clerk.
Okay. And Judge, if next, since I have the translator here, he's scheduled for 1:30, but if Mr. Gabriel Reyes is here, we can address him with the translator.
Gabriel Reyes, is he in the back?
It's set for 1:30. I just want to, before I release the translator, till this afternoon.
What will we be doing? Disposing of the case altogether because it was set for hearing, right?
Negative, Judge. It's set for arraignment at 1:30.
Oh, arraignment, okay.
And I've already spoke to him at the jail. We're going to enter not guilty.
Is he here?
He's here for the downstairs, but you need to draw it. I'll do all that, and he's not following.
Yeah, we just wait and see what happens, just because I don't want to upset we've got the holding area full, so.
Yes, Judge, certainly. I'll turn it over and I'll release it after.
All right, thank you, Madam Interpreter. All right, Mr. McKinney, you have folks in the courtroom?
I think he's talking to somebody, Your Honor. I'll go grab him out of
All right, thank you.
Mr. Lelllo back, Your Honor.
Yeah, you ready, Mr. LaPella?
I've been ready, Your Honor.
Okay.
You can approach again if that's okay.
Yes, sir.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a
Mr.
week.
McKinney.
Normal hours that you've been expecting, but now we're open Saturday.
Yes.
Eubanks. Mr. Brendan Eubanks is the court in 24 CF 1768. In this matter, I filed a C4 motion to dismiss, if I can talk today. In speaking with the state ahead of today, I certainly don't want to put words in their mouth, but I believe that they do not intend to traverse the motion to dismiss.
That's correct.
The motion to dismiss covered counts 1, 2, and 3. Outstanding would be count 4, which is a first-degree misdemeanor. And I believe the state may have an announcement as to count 4.
The state will dismiss count 4 this time, Your Honor.
All right, so the motion to dismiss is granted. The counts the motion to dismiss was addressed to are dismissed. With the state's announcement as to the outstanding count, then the case is dismissed. Is that the state's intention?
Yes, sir.
Matters dismissed.
Thank you, Your Honor.
Thank you, Judge.
We covered all, Madam Clerk. Okay. All right. Anyone else in the gallery? Mr. McKinney.
The remaining matters I have are incarcerated.
Okay. All right. You can start calling your incarcerated folks. Oh, I apologize. One last. Mr. Morales, Alexis Morales. All right. It appears you've completed the application correctly. You do qualify. The clerk will review the form. If the clerk says you don't qualify and you think the clerk is wrong, get everything you believe shows the clerk is wrong, give it to your lawyer and bring it to you, bring it with you to court next time, okay? I'll appoint the public defender to represent you in this matter. And we'll set your court date for 4/17? 4/17.
April 17th is your court date. Do not wait until April 12th to call me.
Now, be sure to get in touch with Mr. Kleins. It's important he has access to you so he can help you resolve your case.
Sir.
All right, thank you, ma'am.
Thank you. Your Honor, before we get to the, you're good. You're good. Before we get to the inmates, I did notice Mr. Crooks is without an attorney on the docket.
That, if I'm not mistaken, there was his attorney, I believe, filed some sort of notice of cancellation.
Yes, Mr. Crooks, thank you for that. I believe you've actually did retain counsel, right, Mr. Crooks? And if you'd approach y'all, so we don't put this on.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Blair.
As to Stowfall with Mr. Uferman, is he going to be here or remotely, or do we know?
Judge, I don't believe so. There was a evidentiary that was set for June 19th at 2:30, and there was a notice of cancellation on the 4th filed by Mr. Offerman for today.
For today, okay. You got that, Madam Clerk? Stoffel, Stoffel, 14 CF 1876.
Yes.
Okay.
You have yours? Yeah, okay. Yeah, I know you did. There you go. Your Honor, this is Christopher Blair, 20 CF 474. Mr. Blair is signing a plea agreement to resolve this violation. At this time, Mr. Blair would be admitting the violation of supervision. The agreed-upon disposition is that his previous supervision would be revoked and terminated. Mr. Blair will be sentenced to 11 months, 29 days, Okaloosa County Jail. With credit for all time served, he'd be assessed a $100 cost of prosecution, $150 in public defender fees. He has previously been adjudicated. I think I said this will revoke and terminate his supervision. And I did not write it on the plea agreement, but there was a failure to appear. I don't believe the state's going to take any action.
The state is not going to take any action on that failure to appear, Your Honor.
State takes no action on the failure to appear. All right.
Your Honor, I'm sorry, for the record, this is a downward departure for the purposes of a legitimate uncoerced plea bargain.
Thank you. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you put your hand down. You heard what Mr. Klein said. You signed the written plea form?
Speak up.
Right.
Yes, sir.
All right. Now, do you understand, according to this plea form, you're admitting the violation?
Yes, sir.
And that says to me, Judge, I violated my probation just the way the affidavit report says it did.
Yes, sir.
Do you understand by making this plea, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
And in this case, you're going to be adjudicated guilty, served 11/29 in the county jail, credit for time served, your probation be revoked and terminated. You'll have some fees and costs. And any outstanding financials will be, have to be paid as well after you finish your sentence. How much time do you think you'll need to get those fees and costs paid?
Now that my wife is actually in a treatment facility, physical rehab, I should be able to get a job much easier. I was her full-time caregiver. So I would say, I think it's $5,000 or something like that. So maybe a year and a half, 2 years.
All right. I'll give you 24 months to pay. If you need more time and you're making payments, all you need to do is ask.
Yes, sir.
But you have to be making payments for me to give you more time, you understand?
Yes, sir.
Okay? The court find the plea to be freely and voluntarily entered into and accept the plea. That's a revoke and terminate. Good enough. All right. Thank you.
Next will be Brandon Lee.
Signed and dated here. Your Honor, this is Brandon Lee in 22 CF 1380. Mr. Lee is executing a plea agreement right now to resolve the violation allegation here. At this time, Mr. Lee is going to admit, today is 2/13. The violation of supervision, the agreed upon disposition is that he will be reinstated to supervision. All prior conditions of supervision will be reimposed. There will be an additional $100 cost of prosecution and $150 in public defender fees. The state is graciously agreeing to continue to withhold here just for Mr. Lee's benefit. If there's any future violations, I fully expect you will be adjudicated guilty. All right. Your Honor, may I pass this forward?
All right, and this includes the second addendum violation on 12/19?
Yes, Your Honor.
Yes, Your Honor.
All right, score sheet?
I believe with a reinstatement, we shouldn't have to have a score sheet, right? Am I wrong? I'll get one, Your Honor.
Okay.
Yeah.
All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right. Excuse me. You heard what Mr. Klein said and you signed the written plea form?
Yes, sir.
All right, do you understand by this plea arrangement you're admitting the violation?
Yes, sir.
And that tells me that you believe you violated just the way the affidavit and report filed by your probation officer says you violated.
Yes, sir.
And by doing that, you understand you're waiving your right to a hearing where the state would have to prove that violation.
Yes, sir.
In this case, you'll be reinstated to supervision with all the terms and conditions plus the additional fees and costs that were announced. The adjudication will be withheld. And this does include the second addendum violation as well.
Your Honor, I would note that, and I'm sure Mr. Gomez will jump in if I'm saying this wrong, but the state's main primary goal here is to get this restitution paid. The restitution is $8,500. Given that significant amount of restitution, would the court consider waiving the cost of supervision so we can put
State object to the waiving the cost of supervision so long as the defendant is paying restitution.
No objection, Your Honor.
Cost of supervision will be waived so long as the defendant is making his restitution payments as directed by the original terms and conditions.
All right.
Thank you.
Court will find the plea to be freely and voluntarily entered into and accept the plea.
All right. Thank you. Your Honor, next I have on the docket is Julian Lelllo. He's on the morning docket in 22 CF 3007. I filed a waiver for Mr. Lelllo. I tried to file a written denial, and the clerk advised us that that's not going to take this off the docket. Mr. Lelllo has a new charge in 25 CF 10. That is on the arraignment docket this afternoon. I did file a written not guilty plea in 25 CF 10. Mr. Lelllo currently scores in the neighborhood of 42 months. I would like to enter a denial in 22 CF 3007. And just ask.
And the violation is the new charge, correct?
Correct.
So, Madam Clerk, if you'd attach the violation to the new charge, you want to set it on 310 or you want to keep it out in May, Mr. Kleins?
I would ask for a one-cycle continuance. I did meet with Mr. Lelllo at the jail this past couple days, and we talked about this. So I was going to ask for a continuance to the May docket.
And that new case number is?
25 CF 10.
Okay. All right.
Is that May 12th is the new date?
Madam Clerk?
I apologize.
Is it May 12th?
Yes.
Awesome.
Mary Mason?
Proposed order.
Yeah, I have a question.
Make it quick.
No, okay.
Your Honor, if we could pass Ms. Mason to the end of this docket. I was talking to Mr. Gomez. I need to talk to Ms. Henderson, so we can just pass her to the end of the morning docket.
All right, well, just we'll keep
Well,
Ms.
hold on.
Mason.
I sent an email to try to be efficient. I sent an email to Ms. Anderson. She is not here today. She said that you could either have a 9 a.m. appointment tomorrow or a 1 p.m. appointment tomorrow.
I'm sorry, Mr. Gomez, what was that?
Terry's not in the courthouse on today.
Okay.
She said she'll be happy to meet with Ms. Mason tomorrow, either at 9 a.m. or 1 p.m.
So you're released from custody today. We get to talk to Ms. Henderson tomorrow at 9 a.m.
And where's that at?
Second floor of the courthouse.
Oh, yes, most definitely.
Okay.
Your Honor, what I just handed Mr. Gomez was a proposed order, essentially going to set bonds for Ms. Mason's cases on her VOP cases at $1,000 signature. Can we approach just briefly to explain this to you?
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
All right, based upon the state stipulation, the bond, she'll be released and it's CC sanctions.
We don't do CC sanctions, Your Honor, on bonds unless you're going to put the whole entire shebang on CC.
Well,
So she's going to
If
eventually,
you have her active with us, we have to supervise her.
she's going to be moving into drug court. So she's going to be on CC sanctions in 2
Okay,
weeks.
when she moves into drug court, but when she gets out, until she goes into drug court, we cannot supervise her on
That's right.
bond with CC sanctions.
That's right.
We're not allowed to do that. In drug court, they can, but not until she goes into drug court and Ms. Johnson gains her case. Because we have her active.
That's right.
If she weren't
That's right.
active
That's
on
right. Thank you
probation
for
with us,
reminding me of that regulation. I
yeah,
apologize.
then it wouldn't be a problem.
You want to put her on intensive pretrial release then?
That's fine. Your Honor, if we could pass her to the end of the docket, I'll rewrite that order.
Well, no time like the present.
It's
Sit
probably
with
gonna be
Mr.
less
Gomez
intensive
and
than
interlineate right now, and I'll initial it.
Yes, sir.
I'm sorry, sir. I didn't hear you.
No, I was talking to Mr. Kleins, and I said, Mr. Gomez, let's fix that. We'll interlineate the order right now so that you don't have to come back and we move our docket on.
Okay, thank you.
Thank you, probation.
Yes, sir. Thank you.
I'm trying to think of pretrial services.
So the difference is you'll have to report to pretrial services when you get out, and they'll arrange for your intensive pretrial services release as opposed to probation putting you on community control sanctions.
Okay.
That's the difference in this order. Once you enter drug court, if they accept you, then you will go on the community control sanctions. The circumstances are the same, the supervision is the same, it's a different group that will be doing your supervision, okay?
Yes, sir.
Your Honor, actually, in reviewing this, I totally forgot to put community control sanctions.
Okay.
It just says, and the state's position essentially is if she doesn't show up tomorrow morning, we're going to move her.
Okay. So you're acceptable the way it is, Mr. Gomez?
Yes, Your Honor.
Okay, very good. Thank you now.
No, that's for you. You handle that stuff, sir.
Thank you, probation.
Say again?
Your Honor, can we,
And yes, we'll set it for status on 2/20.
Okay.
Status on 2/20.
That
And if-
means you don't have to be here unless you're in jail because you didn't go to this appointment tomorrow. You should.
And so basically, ma'am, the reason we do that is that's our control. If there's something going on, if the paperwork isn't caught up, that's our control. Mr. Kleins will tell you if you need to be here or not, okay?
Ms.
Okay,
Mason,
thank you now.
I'm sorry, Judge, I just want to make sure that Ms. Terry is aware. I'm going to let Ms. Terry know that you will be at the 1 PM meeting, just because I don't want to create a bind between.
1 PM tomorrow?
1 PM tomorrow, second floor, she has her name on her office, and the second floor of the courthouse.
So not 9?
Not 9. I don't want there to be any sort of hiccups with when you get out
Thank
and
you.
all that.
Thank you.
So 1 PM, I'll let her know that she'll be there,
I
okay?
appreciate that so much, sir.
There. All right. All right.
All right, now
That's not
grab your
easy.
paper from probation before you walk out. Over there, they'll hand that to you, okay?
Your Honor, next I have on the docket is Heather McDowell. I don't really recall why Ms. McDowell is on today's docket. I can tell the court I did confirm yesterday she's still in custody in the Escambia County Jail, and she has a future court date over there, I believe in April.
Well, I show her on the docket for a status conference.
That's correct.
If I'm not mistaken, Your Honor, at the pretrial date, the state was still in the position, we were trying to get a collection of discovery from the victim over to Mr. Kleins. We have since done that. I think that was why this was set, was just to make sure that we were properly getting everything out.
Right, I see your discovery exhibit on 2/6.
Yes, Your Honor. So we got all the discovery that we got from, because there was an extra amount, even more than what we had gotten originally. And so I think that we had set this for a status just to make sure that we had gotten that discovery.
That's what my notes say. And we're set for 5/12.
That's correct.
Right. So we need to address her detention status in Escambia at that point in time?
I'm keeping tabs on it, Your Honor.
Okay.
And as a matter of fact, I just noticed yesterday, it looks like she's actually been served with a VOP warrant, I believe, out of Santa Rosa County too. So she's 3 out of 4 for the circuit.
Okay. All right, well, let us know where we're going, because if it doesn't look like she's going to be back for 5/12, then let's be proactive about what we're going to do with it. Okay?
Absolutely. Yes,
Okay.
sir.
All right, so we'll leave it on for 5/12, and we'll just mark it off that the status is announced, the discovery complete, Madam Clerk.
David McLoud? Your Honor, this is Mr. McLoud. We did make an argument in front of Judge Brown in December on Mr. McLeod's motion to dismiss. Judge Brown did recently issue a written order denying that motion.
Yes, I see that order on 2/6.
And just so the court's aware, in that order, Judge Brown had written that Mr. McLoud has 30 days to appeal that order. Yesterday, I talked to an attorney in the Second Circuit Public Defender's Appellate Division. She believes that that is incorrect, that this is, because it's not a final order, the case is not final, that 30 days doesn't apply. So I just wanted the court to be aware that that was one of the reasons I was trying to look into this. I didn't want to inadvertently miss an appellate window for Mr. McLoud. I am handing him Rule of Appellate Procedure 9.140. That attorney did advise me to give that to him so he can review it himself. I don't believe that that 30-day window does apply. I will say today, the judge, we are going to want to set this for an evidentiary hearing with subpoenas in the month of April.
All right, 4/17 at 2:30.
Thank you, Your Honor. I'll come talk to you, okay? Your Honor, next I have on the docket is Kevin McNamara. Mr. McNamara has 2 new law violations and looks like 4 VOPs. The new law violations already went through arraignment in the month of January. Today.
McNamara?
No, this is Mr. Mila. I filed a waiver for Mr. McNamara today. I met with him at the jail on Tuesday. He asked me to file the waiver. This is just a VOP arraignment. If we could enter denials on the VOP cases, and those case numbers are 24 CF 1360, 24 CF 642, 23 CF 90, and 22 CF 2789. The basis for these violations are the new law violation, or the new allegations. In those new law cases, Your Honor, all total, the state is currently proposing 116 months to Mr. McNamara.
What is the new law violation case?
There's 24 CF 2861 and 24 CF 2869.
Okay.
And they had their arraignments on January 23rd. So we can enter denials on the VOPs today, given the nature of the state's offer and the seriousness of the allegations. I would ask the court to continue all of Mr. McNamara's cases to the May 12th pretrial docket.
Is that where they're currently set, Madam Clerk?
They're currently on the March 10th.
They're currently on the March 10th docket, Mr. Clients.
Yes, I'm aware of that, Your Honor. I have to look into a potential alibi defense, but there's definitely going to be depositions taken, and even right now, we're booking depositions into late April.
Okay. Does the state agree to continue the 2861 and 2869 cases, even though they're not on the docket today, to the May docket?
Yes, Your Honor.
And have all the VOPs travel with?
Yes, Your Honor.
Okay, so because I'm just looking, those, it looks like those had a arrest date of 12/17 and
They were arrested on the same day. It was
yeah,
two charges,
both
kind of
12/17.
very close in time. No objection, Your Honor.
All right, so Madam Clerk will move the 2861, 2869 to 512, and we'll have the 4 VOPs travel with, enter a denial on those cases.
And next I have Raul Mila. Your Honor, Mr. Mila is before the court today on a second motion for order to show cause against Fort Walton Beach police officer Edgardo Santiago, who is in the courtroom. The defense would like to call Mr. Santiago, or Officer Santiago, to the stand.
All right. Raise your right hand for me, please, Madam Clerk. Will you swear the witness?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Please be seated. Direct your voice to the microphone in front of you. Speak clearly and distinctly so a good record be made. If there are any objections, stop speaking immediately until you receive an instruction on how to proceed. Is that right, sir?
Yes.
Okay. Mr. Kleins, you may inquire.
Officer, do you recall being the subject of a previous motion for an order to show cause in this case?
Yes.
Do you recall coming to the courthouse on August 15th, 2024 for that hearing?
What day was that again?
August 15th?
I don't recall.
Do you recall coming to the courthouse for that hearing?
I believe so.
Okay. Do you recall talking to me about missing that deposition during that appearance in court?
Yes, through email as well.
Okay. Do you recall that motion being withdrawn after we received assurances that you should be at another subpoena, that you would attend another deposition?
Yes.
Do you recall being served a subpoena that was issued on August 2nd for a deposition date of November 6th?
For that subpoena, for that day, I did not receive a subpoena.
Are you saying you were not served?
I don't recall which day, which subpoena date it was, but I did not receive one. And I was not served, and I clarified that through my records department, who also did not receive a subpoena.
Your Honor, may I approach a witness?
Granted.
Your testimony today is that you never received that subpoena? This is the subpoena.
Yeah, I'm seeing what day it is. I'm pretty sure it was one subpoena, I think, for November. I don't remember which November date it was. There was a subpoena that I did not receive. This one is for November 6th. I don't have my phone with me, so I can't verify if I received this subpoena or not.
Okay. Do you recognize the signature of the person who did accept the subpoena?
Yes.
And who is that person?
That's Chantel Hunt, our records supervisor.
Okay. Does she accept subpoenas on behalf of officers of Fort Walton Beach Police Department?
That's correct.
Does she always provide those subpoenas to the officers?
Yes.
And so, would you agree that in her normal course of operation, she would have provided you that subpoena?
Yes, that's correct.
Okay. Is there a chance you overlooked it?
Big possibility. I receive a lot of subpoenas.
Okay. How many subpoenas do you receive that had previously been the subject of an order to show cause?
For this particular case?
No, I'm just talking in general. You say you receive a lot of subpoenas. That's fair. How many times do you receive subpoenas that you have previously had issues with not attending?
Within my 13-year career, I probably missed 2.
You've missed 2 in 13 years?
Yes.
And are those both in this case?
No, sir.
Well, you've missed 2 subpoena depositions in this case, right? I mean, I've had to ask the court before. I was going to ask the court until you gave me assurances that you were going to be there.
Yeah.
That didn't put a red flag, like, hey, if this comes in on this case, let me know?
I was unaware that I missed 2 subpoenas for this case. I know I had missed 1, which we were able to verify that I did not receive it. So this one, like you said, it was signed by Chantel, and I may have received a cancellation for another subpoena and thought it was this one, and that could have been what the issue was.
Who verified that you didn't receive the first subpoena? Because you can go ahead and flip if you want and look at the first subpoena. So you're saying you didn't receive that subpoena either?
No, this one I should have received. You said the only one that I did not receive was one from November, which I don't know the exact date was. This one being in June, I should have received all the other subpoenas.
So this is an issue with Ms. Hunt? Is that what you're saying?
No, she did everything correctly, then it's not her issue.
Okay, so then whose issue is it? You're saying you didn't know about it, but she accepted service, and in her standard business practice, for lack of a better way of saying it, she makes sure you guys get these.
Yes, that's correct. I'm pretty sure that I've always attended every subpoena that I go to and depositions. We get cancellations and email cancellations, and if they canceled us, then I don't go. Like I said, this is the first time I'm hearing about this.
You just testified you came into court in August of 2024 for the same exact issue, right?
We never talked about, we've never talked about a missed subpoena until just recently, where Gomez sent me an email about it.
Why did you think you came to court in the month of August of 2024? Just to observe proceedings?
I'm pretty sure there's a reason for it. They don't give me too much information on that. If I need to testify against the case, then yes, I'm going to testify against the case. But for that one, I wasn't unsure.
Okay, well, your agency accepted these 2 subpoenas, correct?
Yes.
Okay. And your testimony today is that both times you did not know that you had to be at a subpoena, or at a deposition. That's your testimony?
Yes, sir. Don't have any other excuse other than, there's either I thought they were canceled. I'm pretty sure I received a subpoena, so I'm thinking they were probably canceled, and I made a mistake.
Okay. What assurances can you give this court that if I issue a 3rd subpoena, you will actually attend?
Well, yeah, 100%.
Okay, well, this is the second time, this is the first order to show cause hearing I've had to do in years. So this is not a common situation here, and I get it. I mean, you guys get a lot of subpoenas. I have no dispute about that. But you've previously been in court for a missed deposition, and now you're back in court and actually on the stand this time for a second missed deposition, and your entire testimony is basically, I didn't know about it. And I'm sorry, that doesn't seem believable, frankly. I mean, what assurances can you give the court now that if I issue a 3rd deposition subpoena, that you will actually attend that subpoena or that deposition?
The fact that this is, I'm actually on the stand right now for this would be 100% proof for me to come. I had no idea I was going to be on the stand for this. So, sir, as a 13-year-old veteran, I'm not trying to, go out of my way to not go to these subpoenas. Like I'm going to do what needs to be done. It's not something that I purposely decided to do.
Your Honor, the frustration I have is I'm done. Yes, Your Honor, I'm done with the questions I have.
State, do you have wish to inquire?
Sergeant Santiago, can you explain to this court just the general process that the Fort Walton Beach Police Department goes through whenever a subpoena is issued to one of their law enforcement officers?
Yes, the subpoena comes through to our records department. The records department scans it, sends us an email, and then gives us an actual copy in our box, which we check every day that we're at work. And so we have, not only that, they have a system in place where all the subpoenas are in a generalized network on a computer where you can just look it up at any time.
Do you recall on November 6th of 2024, me sending you an email?
Yes, sir.
Do you recall responding to that email?
Yes, sir.
Do you recall what you had stated in that email to me?
Yes, sir. I said that I did not receive a subpoena, and I had verified through Chantel Hunt, and she also verified that I did not receive a subpoena.
Okay. Was it your intent to miss the deposition that was scheduled on November 6th of 2024?
No.
Okay. If this deposition was reset, would you guarantee your attendance at that deposition?
Absolutely.
I have no further questions, Your Honor.
I have no other questions, Your Honor.
May the witness step down.
Yes, sir.
Thank you. You may step down.
Thanks.
Your Honor, the frustration I have is in this particular situation, Mr. Mila is facing significant punishment here. I don't know what the court is aware of, considering all of his cases. This motion here only applies to one, but in total, Mr. Mila is looking at maximum criminal exposure of 3 life sentences followed by 45 years and 60 days in prison / jail. The situation in this particular case, Your Honor, is that Sergeant Santiago is one of only 2 or 3 listed witnesses in this particular case. And I'm trying to get these cases processed forward so we can get a resolution. This is a situation that has caused significant delays. I mean, the first subpoena deposition went out last summer, and he didn't show up for that, which that happens. It is what it is. But given the seriousness of the case, that's why I filed the first motion for an order to show cause. Sergeant Santiago was present in court on August 15th. I talked to him. He specifically advised me that he would attend the next deposition. Knowing that that was probably what was going to happen, I had issued the second deposition subpoena 13 days before he showed up to court. November 6th comes around. He claims he doesn't know about it, yet he emails Mr. Gomez. How does he not know? How does he claim to not know about it, yet conveniently enough, the day that the deposition is actually supposed to happen, he's communicating with the state attorney's office? It's like having a client who calls me the day after getting an FTA, and I'm like, when's my next court date? And it's sort of like, okay, what a coincidence. You happen to call me the day after you miss court. It seems pretty convenient. I want to get these cases resolved. Mr. Mila has a 25-year offer. There are real victims, alleged victims in these cases, and it's being held up because Sergeant Santiago can't bring himself to come in for a deposition here. So I'm not going to stand here and ask the court to hold him in contempt. I think he got the message. But if he does it again, I'm certainly going to be asking this court to take him into custody for a day. I don't know what else we can do to force the compliance. And Fort Walton Beach Police Department is the one agency that we have the most trouble with on compliance with subpoenas, period. They always have. So I don't know how the court wants to handle this, but I'm in a position where this is going to have to be continued so I can take his deposition, or at least try to, for a third time. So I'll turn it over to the court. I'll defer to the court on how the court wants to handle this. But I meant what I said. I very rarely actually put officers on the stand. If they show up 9 times out of 10, hey, just show up to the next depot, I'll withdraw the motion. That's exactly what I did in August, and now we're here again because he didn't show up again in November. So I'll defer to the court.
Mr. Gomez.
Your Honor, I just wanted to clarify in the situation regarding the email that was sent on the date of the deposition. That was because I had sent an email to Sergeant Santiago indicating to him, hey, we had reset this second deposition. You didn't show up. I can tell you right now the defense attorney is going to file a second motion for order to show cause. That was when he had replied back and said the same thing that he said on the stand today. He spoke with his record supervisor. He had no record or knowledge that he had received a subpoena for that date, and that he was currently on a night shift schedule. And he had just woken up, and then he had asked to reschedule the deposition. I had forwarded that email to Mr. Klein's. I understand Mr. Klein's frustration. I can't speak to the ins and outs and the intricacies of the Fort Walton Beach Police Department's service of their subpoenas upon their law enforcement officers, but from the testimony of Sergeant Santiago, I think the fact that he has been here 2 days, I understand that it has caused delays. However, I don't think that this was any sort of willful attempt to avoid a deposition. I think him being here, going onto the stand, and his acknowledgement that he would most certainly be here on the third attempt for a deposition, I will do everything in my power to make sure that once the deposition date is set, I will be in direct contact personally with Sergeant Santiago to make sure that he appears and has knowledge of that third deposition date, Your Honor.
All right. So it's 11, so it's time for a comfort break anyway, and during that comfort break, you and Mr. Kleins are going to set the date, and I'm going to charge the officer to be present, and I'm going to set the deposition by order of the court for him to be present at the deposition, and that will set the stage if he fails to appear at that deposition based upon the court ordering him to be present. So during the comfort break, you'll set the date, and we'll charge the officer to be present, and then you'll follow that up with an order setting the deposition on that date and ordering him to be present.
And just briefly, Your Honor, I know Officer Sergeant Santiago is not involved in the 3 other cases, but on 2513, we would ask that the continuance that is going to be necessitated here be charged to the state. I'll take the continuances on the other cases. And then the last thing.
Arguments against?
No, Your Honor, that's fine.
So ordered.
The last thing I'll tell the court is, from now on, just to clear up any confusion, if we have any future, not with any Fort Walton Beach Police officer, if this is another issue, we'll make sure to get Ms. Hunt in here at the same time, so we don't have to sit here.
Well, I'm not going to prejudge any of that.
Certainly.
You try your case as
Understand.
you feel is necessary and make your motions you feel is necessary.
Yes, sir.
All right. Now, before I take a recess, Mr. McKinney, if you and Mr. Gomez approach on Mr., or whoever it is, on Mr. Castor, who's handling Mr. Castor?
Yeah, I spoke to Mr. Snell about that.
Okay, come on up.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell.
All right, we'll take a 5-minute comfort break.
850-306-2667.
Counting down. Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Yes.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
this is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthe from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help active victims. Hi, I'm Attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
He had the reverse split. So, on probation, he violated, of course, 17.9 for something. When you originally played this out, so from the arrest date to when you played the bench.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Remaining custody, except 5 years of use. So from 12/24/2019 to today, so that's just once days, plus the correct beforehand.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years.
April 14th, 2025 at 12 p.m. Is it all right on that order, Your Honor, if I should mark out 2024 and write 2025?
Yes.
Thank you, Mr. Goodness.
All right, officer, you've heard the date. Yes. You acknowledge your requirement to be present. Yes, sir. And you'll so be ordered. All right, can you print a copy of this?
My printer is broken.
Say again?
No, my printer is broken.
Did you print copies?
I just gave him a courtesy copy.
Your Honor, there's a courtesy copy of it.
And I just also told him we will issue a formal notice subpoena. But
Okay. All right, thank you. Next case, please, Mr. Kleins.
Your Honor, I have somebody in the gallery that she'd come in a little bit late, but Jenna Lenton.
All right, who is that?
Jenna Lenton.
All right.
And just to verify on the last case, all of the cases were continued to May 12th.
That's
Correct.
yes.
That's correct.
Linton, you say?
Yes, sir, Your Honor. This is Miss Lenton. She is on today's docket in 23 CF 1470. She is signing a plea agreement right now to resolve this, Your Honor. The agreed upon disposition is that Miss Lenton is going to be admitting the violation. The agreed upon disposition is that she will be sentenced to credit for time served. Her supervision will be revoked and terminated. Originally, in this case, Your Honor, she did have a withhold of adjudication. Speaking with Ms. Linton yesterday, she was adjudicated in Walton County of a felony, so she will take a felony in this here, so she will be adjudicated here. She would be assessed a $100 cost of prosecution, $150 in public defender fees.
Brother?
And Your Honor, for the court's knowledge, I will be printing out a score sheet, and when I get a chance to run downstairs, I'll grab them and come back.
All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
All right. You can put your hand down. You heard what Mr. Klein said. You signed the written plea form. You understand you're admitting the violation?
Yes.
Which says that, to me, that you agree that you violated your probation just the way the affidavit report filed by your probation officer says you did. You understand you're waiving your right to a hearing where the state would have to prove that violation.
Yes, sir.
And you're sentenced to time served, your probation be revoked and terminated, you'll have the additional fees and costs. If you have any outstanding fees and costs, you'll be obliged to pay those as well. How much time do you need to have those things paid?
180 days.
180 days to pay. If you need more time, as long as you're making payments, ask and I'll provide you additional time. But you have to be making payments to get the additional time. Do you understand?
Yes, sir.
Find the plea to be freely and voluntarily entered into, and I'll accept the plea.
Your Honor, this is Nora Mullins in 23 CF 2281. Ms. Mullins has reached an agreement to resolve this with the state. The agreed upon disposition is that Ms. Mullins will admit the violation. She will be sentenced to credit for time served. Her supervision will be revoked and terminated. She would be assessed a $100 cost of prosecution, $150 in public defender fees. She has not previously been adjudicated, and I have discussed with Ms. Mullins the fact that we could probably continue a withhold, but she wants to go ahead and kill this probation with a county jail sentence. She is aware that she would be adjudicated for the first time.
Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
All right. You put your hand down. You heard what Mr. Klein said, and, sorry, Mr. Gomez?
Were you handed a score sheet, Your Honor?
Yes, I was. You heard what Mr. Klein said, and you signed the written plea form.
Yes, Your Honor.
You understand by this plea arrangement that you're admitting your violation?
Yes.
And that says to me that, Judge, I agree that I violated my probation just the way the affidavit report says it did.
Yes, Your Honor.
And you understand you're waiving your right to a trial where the state would have to prove your violation.
Yes.
Now, Mr. Kleins has raised the issue about your adjudication of guilt. This plea arrangement requires you to be adjudicated guilty of this charge. Do you understand that?
Yes, Your Honor.
And Mr. Kleins has explained the consequences of that adjudication to you.
Yes.
In addition, so this is credit for time served, revoke and terminate, and some additional fees and costs. You may have some other outstanding fees and costs to pay. How much time will you need to get those paid?
Could we do a year and I can pay it off sooner probably?
All right. I'll give you a year to pay, and as long as you're making the payments and you need more time, you need to ask for more time, and I'll give you more time as long as you're making payments. If you're not making payments, I won't give you more time. You understand?
Yes, Your Honor.
Okay. Court find the plea to be freely and voluntarily entered into and will accept the plea. Thank you, now.
Jason Neely?
Neely.
Your Honor, this is Mr. Neely. He's got 4 cases on today's docket. This is my email is right there. Okay. I talked to Mr. Gomez. We're not in a position to resolve this today. I would ask the court if we could pass Mr. Neely's case over to next Thursday. I did propose a new alternative to Mr. Gomez. I'm also going to hopefully be getting some mitigation documentation between now and next Thursday. So if we could pass this to next Thursday, Your Honor, I would really appreciate that.
Mr. Gomez?
No objection, Your Honor.
All right, it'll be passed till 2:20.
I'll see you either Monday or Wednesday. Okay. All right, man.
Valerie Norris? Valerie Norris?
Yes.
I'm sorry. Ms. Norris is signing a plea agreement. Today's the 13th. At this time, Ms. Norris is going to be admitting the violation. The agreed upon disposition is that Ms. Norris is going to be reinstated to supervision. That supervision will be modified to add 24 hours of community service. There will be a $100 cost of supervision, $150 in public defender fees. The state has agreed to continue Ms. Norris's withhold I just want to be clear that Ms. Norris's current termination date is in November of this year, so she's going to have 48 hours of community service that she needs to get done before really the end of September.
Will do.
It'll be coming.
All right, in addition, we've got the prisoner transport cost that will be added to her costs, which are $87.60 requested by Escambia County.
She has no objection to that, Your Honor.
I'm sorry, excuse me, Okaloosa County. All right. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand in. You heard what Mr. Klein said and you signed the written plea form?
Yes, sir.
Do you understand that you're admitting the violation?
Yes, sir.
And that says to me that you agree that you violated your probation just the way the affidavit and report by your probation officer says you did?
Yes, sir.
Okay. Do you understand by making this plea, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
In this case, adjudication will be withheld. You'll be reinstated to your supervision with a modification to include the 24 hours community service, the additional fees and costs, including the cost of transportation. And as Mr. Klein said, this is to your original termination date, so you'll have to, put some steam on to get it done. You
Yes,
understand
sir.
that?
Yes, sir.
All right, the court will find the plea to be freely and voluntarily entered into, will accept the plea. Now, as you pass by, they're going to pass you a piece of paper. You need to be aware that once you leave, you're going to need to report immediately to probation,
Yes, sir.
okay? All right, thank you very much.
Thank you so much.
Your Honor, I'm sorry, Ms. Norris had asked me to request if the court would consider waiving the cost of supervision until she gets a full-time job. She's been in custody for about 40 days at this point.
State, objections?
No objections, Your Honor.
All right, the court will waive the cost of supervision so long as the defendant is not gainfully employed. All right.
Thank you.
Judge, may I jump in with Mr. Castro?
You may, sir. All right, and so this is 22 CF 2815. I've communicated with Judge Clark. Judge Clark has indicated, based upon the confusion in the court date, that she has authorized me to dispose of this case. Mr. McKinney, I understand that you and Mr. Snell have reviewed the case, have discussed the matter with Mr. McKinney, you with your colleague who represents Mr. Castor, that you're fully informed and feel comfortable that you can represent him in this matter to dispose of it today. Is that correct?
Yes, Your Honor, that is
Mr.
correct.
Snell, you is in the same position? Yes, sir. You may proceed, Mr. McKinney.
Judge, Mr. Castro is here in 22 CF 2815, and I will pose a question to probation. Has Mr. Castor completed all of his conditions?
Yes, sir, he's completed everything.
Judge, he's due to term on the 19th, so I would ask that the VOP be dismissed and that his probation be terminated.
The state would not object to that request.
The violation is dismissed and his probation is terminated successfully.
Terminated today or?
Today.
Today? Okay.
All right? Thank you very much, sir.
Thank you.
And you just pass by them just for 1 minute before you leave. They may have some last-minute instructions before you go. Okay?
Yes, sir.
Thank you now. Good day.
Thank you, Your Honor.
Willie Patterson, Jr.?
And Your Honor, may I have just a brief moment with my client? Thank you. And this is Mr. Willie Patterson in 23 CF 1261 for the violation of probation, Your Honor. And I also requested to have his 25 CF 173 case set also for today, Your Honor.
Yes, sir.
Ultimately, Your Honor, in my hands, I do have a downward departure of 1129 offer. Just to get the court up to speed, my client was released from jail due to cancer diagnosis. Of course, these new laws were picked up and he was arrested. I'm asking to place my client on the 20th docket, February 20th, because my client wants extra time to contact his family. His concern is if he accepts the 1129 sentence, if he will still be alive at that time, and he wants to just run everything by his family. So I'm requesting if we can put this on the 2020 docket, Your Honor.
Okay. Your client wants to say something, talk to your lawyer before you talk to me.
It may have, my bond got revoked, Judge Stone, but there's a place in Houston, Texas, Dr. Anderson, and it's experimental, but it's free. And, you know, I think that the state has a fair offer, but I just don't want to die in the county jail, so I have blood in my stool. My testicles swell real bad, and, you know, I just hadn't, this was just offered to me yesterday, so I really hadn't had a chance to talk with my family.
Yes, sir. I understand that, and so we'll continue it to the 20th so you get a chance to talk to them about it, okay?
Yes, sir. Thank you.
Okay. All right. Very good. We'll see you on the 20th.
You're welcome. Absolutely. I'll see you on the 20th. This judge is Ms. Quayano, last name Purdue, in 22 CF 555. Good morning. Still set to go forward? Okay. Your Honor, this will be an admission this morning, and that is in counts 2, counts 3. It'll be an admission, adjudication of guilt. There's 100 days in the Okaloosa County Jail, credit for time served. There's the $100 violation of probation cost prosecution. There's the $150 defense costs. Probation will be revoked and terminated. All counts to run concurrent. If I may approach with the signed plea form and no objection to the score sheet. Thank you. The jail.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir, I do.
All right, you can put your hand down. You heard what Mr. Klein said and you signed the written plea form.
Yes, sir.
All right, you understand by this plea arrangement that you're admitting the violation?
Yes, sir.
And that says to me that I violated just the way the affidavit report says it did.
Yes, sir.
Do you understand you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir, I do.
In this case, you'll be adjudicated guilty. You'll serve 100 days in the county jail, credit for all time served. Your probation will be revoked and terminated. You'll have some additional fees and costs to pay. You'll also have some outstanding fees and costs, looking like it's about $900. Is that about right, Madam Clerk?
About 800 on our side.
Yeah. And then you have your additional $100 and $150. So you have to pay all of those ultimately. How much time once you get out are you going to need to get those payments made?
Can you give me a year to get it paid, sir, please?
Say again?
Can you give me a year to get it all paid?
Yes,
please?
ma'am, I can. Are you sure you can get it done in a year?
Yes, sir, I will get it done within a year.
All right. And if you need more time, as long as you're making payments, you can ask for more time and I'll provide you additional time to make those payments. If you're not making payments, I'm not going to give you any more time.
I will be making payments immediately.
I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea.
Yes, ma'am.
Your Honor, may I approach real quick? I have some score sheets from other.
Yes,
You're
Mr.
all
Lemons,
set.
you may.
All right, Ms. Purdue. One second. Judge, this is Mr. Raul, last name Perez. On the docket today, it's the 24 CF 903, 24 CF 2182. And Your Honor, I believe earlier this week, we placed the 25 CF 71, 25 CF 74, and the 25 CF 75 on this docket, I believe, Madam Clerk.
Yes.
Totaling 5 cases. Thank you, Judge. I first want to enter not guilty and waive formal readings to all those cases, Your Honor. I did have a tentative plea offer this morning with my client we discussed yesterday, but at this time, we'll be entering not guilty and request that all of these cases be set for that March pretrial docket.
310?
Yes, Judge, and I know the 325 cases were set for that May date. I'm asking if we can put them all on that March pretrial.
State have any objection to moving all the cases up to run together on 310?
No objection.
Madam Clerk?
Excellent.
All right.
Thank you, Judge.
Thank you.
Okay. We'll talk privately. Judge, this is Ms. Kendra Perkins in 22 CF 243, 23 CF 1466. Okay. Your Honor, this will be an admission this morning on both cases, both counts. This will be 100 days in the Okaloosa County Jail with credit for time served. There's a $200 cost of prosecution, the $250 defense cost. Probation will be revoked and terminated. All cases and counts to run concurrent. I have a signed plea form and no objection to the score sheet, Judge. They'll calculate it at the jail. We talked around 50.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand down. You heard what Mr. Koch said and you signed the written plea form?
Yes, sir.
Do you understand by this plea arrangement on these 2 cases that you're admitting the violation?
Yes, sir.
And so that says to me that you admit that you violated your probation just the way the affidavit and report by your probation officer says you did.
Yes, sir.
You're hesitating.
Yes, sir.
Do
I
you understand?
violated.
Okay. And do you understand by making this plea that you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
In this case, you'll be adjudicated guilty. Your probation will be revoked and terminated. You're going to have some additional fees and cost and 100 days in the county jail credit for time served. In addition, you have some substantial fees and costs that are unpaid in your underlying cases that you'll have to eventually pay. How much time do you believe you need reasonably to pay those payments?
I was trying to, when I get out, I was going to try to do a payment plan. Because I know, like, on my probation, I know I owe like $5,000. Pretty sure.
So that might be is there restitution outstanding? Is that what there is?
I'm not sure.
Because I'm showing 965 in one case and 665 in the other. Yes, I'm showing that you have, what, 5892 in outstanding restitution, and that's in addition to the 1,600 or so, close to it, in court costs that you have.
So like a year, right?
Judge, if I may recommend, my client, after she serves this 100 days, of course with credit time served, she'll be going to Walton County on a hold for a VOP over there. If we could put the that restitution at $5,892 to a civil lien and all outstanding court costs if she can get a year to pay upon release.
Okay. Realistically, given all those circumstances, doesn't 24 months sound more realistic to get the payments made? And the reason I say that, ma'am, is that once you get out and you start making payments, if the year comes up, then the clerk's going to take action to be in collection. If you make payments within the year and you need more time, then I'll give you more time. If you don't make any payments, I'm not going to extend the time just with no payments made. So if the 1 year with the hold from Walton County, do you think that'll be enough for you to be in making payments?
Yes, sir.
Okay. And we'll make that after her release from all incarceration.
Thank you.
No, we would not know when she's released.
That's correct. How are we going to do that?
Maybe the judge was offering that 24 months, because that will, by the time you serve your Walton, what happens over there, will give you time to make.
What are the charges in Walton, Mr. Koch? Do you know?
It's a violation of probation, Judge.
What are the underlying charges? Do you know?
A possession of controlled substance and possession of.
Do we know if she scores? Does anybody have any clue about that?
She doesn't, she's not gonna score, I don't think.
Well, I know that my.
I don't want to make any facts on that allegations over there.
Okay.
What I know.
All right, so we'll do 24 months just to be sure, and that's simply because Madam Clerk won't know, and that way give her an opportunity to start the payments, and if you don't, then the clerk will take the actions to collect, and it'll result in the civil lien and other consequences for you, okay?
Thank you, Judge.
All right?
Thank you.
So when you get out, you make payments, just keep receipts and make payments.
Do I have to? Thank you, Judge.
You're welcome. Thank you. Judge, this is Ms. Cindy Ryder in 24 CF 2332. If I may have just a brief moment, Judge.
Yes, sir.
Judge, this will be an admission and adjudication of guilt. It's 180 days in Okaloosa County Jail with credit for time served. There's $100 cost prosecution, the $150 in defense costs. All counts to run concurrent. Probation will be revoked and terminated. I have a signed plea form, and Mr. Snell will provide the score sheet, Your Honor. We're right. This way.
Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, and you may put your hand down. You heard what Mr. Koch said on your behalf and signed the written plea form.
Yes, sir.
All right, you understand that you're admitting the violation in this case.
Yes, sir.
And it says to me that you believe that you violated your probation just the way that the probation officer said you did in that affidavit report. Is that right?
Yes.
Do you understand you're waiving your right to a hearing where the state would have to prove your violation by making this plea?
Yes, sir.
In this case, you'll be adjudicated guilty. Your probation will be revoked and terminated. You'll have some additional fees and costs which will be assessed, and you'll serve 180 days in county jail credit for time served. You've got some outstanding fees and costs that you'll have to pay. How much time do you need to get those paid after your release?
Will you make those payments? I will say give us a judge for
A year.
Okay. And if you're making payments and you need more time, I'll give you more time. But if you're not making payments, I won't extend the period of time. Do you understand?
Yes, sir.
All right. The court will find the plea to be freely and voluntarily entered into and will accept the plea with the adjudication.
Ms. Ryder.
Thank you.
You're welcome.
This will be Tate Smith.
Stay right there. Judges, Mr. Tate, last name Smith, and 2018 CF 1070.
Handle this case in the 12:30 docket or the 1:30 docket?
You wish to move this to the 1:30 docket?
Yes, sir.
Okay.
Or at the 12:30, either one. So,
And if I may, Judge, the client already has a copy of the plea form. Me and Mr. Snell discussed the plea to resolve this morning. He just has to finalize it with his supervisor, Judge.
Okay. And don't forget the $190.80 in cost of transportation to the Okaloosa County Sheriff's Department, okay?
Yes, Judge.
All right. Let's bring it back at 1:30. 12:30, we have 3 hearings, and let's put it 1:30, okay?
See you at 1:30, Mr. Smith. Yes.
All right.
Tyler Force? No worries. Okay. Judge, this is Tyler Forrest before the court in 21 CF 336. This is a violation of probation. We're going to enter a denial. I'd like to come back next week on the 20th, not for a hearing, but for a resolution. I'm waiting on a letter of incarceration from Santa Rosa County to see if that credit would count for anything over here.
Okay.
So if we could just move it until next week.
State?
No objection.
Just, it's a humdinger of a docket already, so.
Yes, sir.
All right, so we'll put it on the 20th for change of plea. And Mr. McKinney, also in that case, we got a cost of transportation, $51.15 to the Okaloosa County Sheriff's Department.
$51.15?
Yes, sir.
Yes, sir. Thanks, sir. Hey, do you have any questions for me? That's what they agreed to. Marvel Huddleston is before the court in 19 CF 690. And we have reached agreement in the felony violation of probation. Mr. Huddleston is going to admit to the violation of probation. He's previously been adjudicated, but he would be adjudicated guilty. 90 days, Okaloosa County Jail with credit for time served, revoke and terminate his probation, $100 VOP fee, $150 cost of defense. Judge, is there a cost of transportation in this case?
I don't see a notice from the sheriff in this case.
Okay. Thank you, Judge. Have you had a chance to read this through? Okay. Have any questions? Okay. It's 19 CF 690. May I approach the plea agreement?
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, and you put your hand down. You heard what Mr. McKinney said, and you signed the written plea form?
Yes, sir.
Do you understand by this plea that you're admitting the violation?
Yes, sir.
And that says to me that you agree with what your probation officer said in the violation report that how you violated?
Yes, sir.
You understand by doing this that you're waiving your right to a trial where the state would have to prove your violation?
Yes, sir.
All right. And you were previously adjudicated guilty in this case. Your probation will be revoked and terminated. You'll get 90 days county jail credit for time served. You'll have some additional fees and costs that were announced. I don't show any outstanding other than that, those amounts. Is that right, probation? I just see the
When I spoke to probation last, it appeared that there might be like $74 in cost of supervision left over. Otherwise, I believe that Mr. Huddleston is taking care of all the court costs.
As the report shows, zero balance. Well, actually, the report shows a 765 balance, but Madam Clerk, I show 0.
It was paid about 6 months after.
Okay.
7488.
Yes.
And the 7488 is cost of supervision. Would the court be inclined to waive the cost of supervision?
I'll
in the
waive the
arrearage?
cost of supervision given the circumstances presented. So you'll have the $250. How much time will you need to get that paid after your release?
A month.
Say again?
A month.
You sure?
Yes.
Okay. Okay. All right. Court will find the plea to be freely and voluntarily entered into and accept the plea who is previously adjudicated. Thank you.
All right, thank you. Thank you so much.
Candy Davidson Rothacker?
No, and I checked. This is Tammy Davidson Rothacker. I believe it's on the docket as Rothacker.
Yes, sir, and that's the way I show it.
It's 23 CF 1029. We have reached an agreement. The agreement that's been reached is to continue the withhold of adjudication with admission to the violation of probation. Her supervision will be reinstated to complete the original requirements and extended by a period of 2 years. $100 VOP fee, $150 cost of defense. May I approach with that agreement?
Yes.
I would note that restitution is a driving factor and one of the conditions that the state's most concerned about. We would consider asking the court for a waiver of the cost of supervision to make sure that the monies are applied to the restitution first.
State's argument on the waiver of the cost of supervision to support the payment of restitution.
No objection.
All right. If you'd please raise your right hand. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
And then you put your hand down. So the outstanding restitution looks to be $55.02. Is that still where we are?
And Judge, one of the original conditions that would be reinstated is $400 a month towards that restitution.
400?
Correct. That's the way it currently stands.
She still owes a balance of restitution of $5,502.37.
Okay. All right. So you heard what Mr. McKinney said and you signed the written plea form.
Yes, Your Honor.
Do you understand by this agreement that you're admitting the violation?
I do.
And that says to me that you agree with what your probation officer said in the violation report of how you violated.
Yes.
Okay, you hesitated. Do you not agree? Do you?
There's one.
Well, talk to Mr. McKinney first before you.
Judge, her concern was that there was a mention of an anti-theft course. She believes that she had completed that. She just needs to show completion to her probation officer.
Okay.
That was only one of the reasons. For
Okay, so other than, so you'd admit you haven't shown proof of that, not that you haven't completed it.
Should I tell you or him? When I was originally arrested, it was in Walton County. So the anti-theft course was done and submitted to Walton County, and I think that they didn't send it over to him.
Okay.
So, yeah,
But other than that, you admit
Yeah.
all the allegations?
Yes, Your Honor.
All right. And so with the substantial Restitution, one of the court's concerns in looking at this plea agreement is the last payment I show is in July of '24. And it also suggests that they were uncertain about where your residence is. And so, in candor, I'm concerned that if I accept the plea with the reinstatement to probation and complete the original terms and conditions with the payment of restitution, with those kind of situations outstanding, what assurances do I have that I'm just not setting you up for more failure? Because with this violation, and you violate again, you're probably going to be adjudicated guilty, and the second violation is probably going to put you in a position of scoring for prison time. So explain to me what's changed at this point in time where you believe I'm not going to face another violation which says absconded and not paying. That, you see where I'm coming from?
I do, Your Honor. Go ahead.
That's
I did just get a job, Your Honor. It's a pretty good job, and I'm back in school. So all of that has made me more stable. And I do have a residence. So I would just say that I'm going to do better. I want to be set up to succeed as well.
Okay. So you do understand the court's concern, and Mr. McKinney was nodding that he's explained to those potential consequences to you, right?
I do, Your Honor, and I'm going to do better.
Right.
This is.
Okay. All right, well, the court will find the plea to be freely and voluntarily entered into, will accept the plea, reinstate the probation, complete the original terms and conditions, extend the probation by 2 years with the additional fees and costs. The court will waive the cost of supervision so long as the defendant is making her payments as scheduled towards her restitution. So the goal here is I want you to be putting your financial resources towards the restitution. If you fail to do so, then they're going to begin assessing the cost of supervision. It's not intended to be a free ride. If you're making the payments, that's the goal, to provide you additional breathing room to do that. Do you understand?
I do. Thank you, Your Honor.
Okay. All right. And it's a continued withheld at this time. Now, you need to report to probation as soon as you're out, and they're going to pass you a notice about that, okay?
Sabrina Tino?
Do you have any questions? Okay. Judge, this is Ms. Sabrina Tino before the court in 24 CF 553. The plea agreement contemplates also handling 25 MM 14.
I'm sorry, say again.
25 MM 14.
14?
Correct.
You got that, Madam Clerk?
Yes, sir.
And that is a one-count possession of paraphernalia in the misdemeanor case. The agreement calls for a continued withhold of adjudication in the felony violation of probation case with reinstatement of her probation to complete original requirements and a modification of the substance abuse evaluation to be completed within 30 days and complete any recommended treatment. $100 VOP fee, $150 cost of defense. In the misdemeanor case, I have included it on the VOP plea agreement, but it is a new law, possession of paraphernalia. The agreement that's been reached with the state in that one count misdemeanor is a plea of no contest, 30 days in the Okaloosa County Jail with credit for time served, adjudication of guilt, $275 in misdemeanor court costs. Please correct me if I'm wrong in that, Madam Clerk.
270.
270? Okay. And then a $50 cost of defense for the misdemeanor case. May I approach with the plea agreement?
Granted.
That's the state's agreement.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, and you can put your hand down. You heard what Mr. McKinney said and signed the written plea form.
Yes, sir.
Now, you have two things going on today. We're taking care of them together, but they're two different things. You have your new charges and you have your violation. Do you understand that?
Yes,
As to your new charges, do you understand you're pleading no contest?
Yes, Your Honor.
And by pleading no contest, I understand you to say that you believe the state has the evidence necessary to prove your guilt and you're not going to contest that.
Yes, Your Honor.
Do you understand by making that plea, you're waiving your right to a trial where the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
All right, as to your VOP, do you understand that you're admitting the violation?
Yes, Your Honor.
And by admitting the violation, I understand you say that you agree that you violated your probation just the way the affidavit report of your probation officer says you did.
Yes, Your Honor.
Do you understand by making that admission, you're waiving your right to a trial where the state would have to prove your violation?
Yes, Your Honor.
All right. And is it withheld on the misdemeanor as well, Mr. McKinney?
No, it would be an adjudication on
Okay.
the misdemeanor.
All right, on the misdemeanor, you'll be adjudicated guilty, and it's going to be 30 days county jail credit for time served. Are the payment of the costs going to be a condition of the probation in this case?
Yes, Your Honor, I would ask that the cost be paid in the felony violation or in the
So the
probation.
275 cost of, in the 24 MM14, plus the $50 cost of defense, will be a condition of the probation in the 24 CF 553. In the 24 CF 553, you'll continue to have a withhold. You'll be reinstated to your probation, complete the original terms and conditions, and you'll have some additional fees and costs. Now, one of the major changes here is the modification to include the substance abuse evaluation within 30 days and complete the recommended treatment that results from that. Why is that important? Because the violation talks about the circumstances that give rise to where you're here in your new violation. Now, the department said that they wanted you to go on drug offender probation with a residential treatment. Now, the states agreed not to do that. So if you fail to do your substance abuse evaluation because of what the state's done in this agreement, they're pretty much going to automatically revoke you if you don't go within 30 days. The goal here is to help you with this. And if you don't do that, then they're going to submit a violation. You're going to come right back here because that would demonstrate you're not willing to accept the real generous offer the state has given you to avoid a residential treatment and be away from your family. Do you understand?
I do.
And I will strictly enforce that.
Yes, sir.
Now, we'll give you what you need to get help, but if you don't reach out and accept that helping hand, there will be consequences for you. You understand?
I do.
You willing to accept that?
Yes, Your Honor.
Court find the plea to be freely and voluntarily entered into will accept the plea. Now, when you pass by, probation is going to give you a piece of paper, tell you to report as soon as you get out, okay?
Yes, sir.
Agreed. Judge, Mr. Ward is here in 23 CF 1151, which is a felony violation of probation. He had a question about the plea arrangement. May I enter in denial and set this on next week, and I'll go visit him in the jail, go over his questions with him?
Yes.
Thank you, Judge.
220.
And that is a...
Objection from the state to the continuance?
No, sir. It's a county jail revoke and terminate, so it will not eat up a lot of time next week.
Okay. All right, very good.
Thank you. Yes, sir.
I showed Ricky Marina.
And then also Beck Parsons. I don't think she's in with Mr. Cobb. So 2 cases with Mr. Cobb. Ricky Minor with Scott Clines.
Mr. Minor with you, Mr. Clines?
Yes, Your Honor.
I have showed 2 cases. One is actually assigned to Mr. Maddox, so that's the misdemeanor case.
Yes, I don't know how, I have that misdemeanor file with, I don't know how it's attached itself to this VOP.
Because it was sentenced with the felony.
Whatever, I still have it. Mr. Minor was in contact with our office this morning. He was in court on Monday for one of the bases for this violation was a DUI. I guess his truck broke down and he's stuck in a hotel room. I just about 10 or 15 minutes ago filed a waiver. I informed Mr. Gomez of all this. We are on the precipice of a conclusion here. If we could pass Mr. Minor's case to February 20th at 9 o'clock, I have told my assistant, when you get in touch with him again, have him here at 8:55 on Thursday morning, if the court would allow us to do that.
State?
No objection, Your Honor.
All right, they'll be reset for 2:20.
Thank you, Your Honor.
And so should we reassign the misdemeanor case to Mr. Clines, just so there's no confusion on the docket?
I'm fine with that, Your Honor.
Reassign the 24 MM 3733 to Mr. Clines, just so the docket's consistent. All right, then, did we do Scott Niles?
He's on the arraignment docket. We had filed I had asked my assistant to see, but I wanted him to be here today no matter what. I didn't realize he had an arraignment today, so we had filed we'd filed a notice for an entry of an early plea. We can just take the plea at the arraignment.
Okay, so it ended up on this docket for the change of plea, and it's on for 1:30 as well?
Correct.
Okay, you see that, Madam Clerk?
Yes, sir.
Okay. And then Beth Parsons with Mr. Cobb, any?
Let's see if I've talked with Mr. Cobb on that one.
And then we got Ms. Wycheck with Mr. Cobb as well.
There's one with Mr. Henderson, but it's also set for the 2:30 as well.
Okay, yes, I saw that too. I think that was just a cross-notice issue.
He's back here, his attorney stated that today was canceled.
Yes.
Yes.
I messaged,
That's Mr. Offerman, right?
Yes, Judge. That was, the notice of hearing for today was canceled on the 4th, and it's set for an evidentiary in June 19th.
Okay. Now, is he currently, let's be sure we don't have an issue with that, you deal with Mr. Offerman. Was he transported here for the hearing, or is he housed elsewhere?
Judge, I believe he's been at previous continued status conferences, but this is Ms. Basso's case. She just left me notes saying that she and Mr. Offerman had continued it to the June 19th. I know that they had instructions from...
You understand the court's concern. Check with Ms. Basso and be certain that if he's actually housed somewhere else, he doesn't end up going back, if that's the situation, right? If he needs to stay here, or just check on that, and if you need the court to enter an order, let me know and work that out with Mr. Ufferman. I don't want us to reset it and then have him not be present for just the administrative reasons.
Yes, Judge.
And then, but anyone been in contact with Mr. Cobb?
I just texted him on, I have Miss Beth Parsons, and then on Wyatt Check, I messaged him on those and asked if he was going to be attending.
And then we have Tate Smith coming back later this afternoon.
Yes, Judge.
All right. Well, let Mr. Cobb know to come on then later, and we'll keep Parsons and Wycheck for this afternoon. And then we'll see y'all at 12:30 for the pretrial detentions. Okay?
Yes, Your Honor.
Mr. Clarence, that may be someone related to one of your cases.
I've already talked to him.
Okay. All right. We're recessed.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Reyes Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Ryder Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just one block south of the courthouse in historic downtown Crestview.
Like me, I went to high school, 5 minutes up there. Charles. Yeah, I don't like that. Charles. Neither do I.
All right. We ready to proceed?
Yes, sir.
Y'all reached an agreement on which case we're going to call first, or?
However you want to call it, Your Honor.
Say again?
However you want to call it, Your Honor.
All right, Charles Little.
Frank Rayford Little.
Yeah, as long as you wake up.
Yeah.
Ms. Herndon, you'll be handling this for the state today?
Your Honor, this is Mr. Charles Little. He is present today. I'll turn it over to.
Your Honor, I have spoken to Mr. Clients, and I'm sure as the court has looked at the progress docket, we have previously had a pretrial detention before Judge Brown on December 26th. It was approximately a 3-hour evidentiary hearing going over the facts of the case when Mr. Little was first arrested. Just so that the court is aware, the facts as they are alleged is that Mr. Little was caring for a child that was not his own. He was romantically involved with the child's biological mother. He was in the apartment with the child during the morning hours of June 7th. At some point during that morning, he called the child, his name was Levi Phillips, his mother, and said, I had an accident. I tripped and fell on the child. I tried to console him. He is freaking out. He shook and fainted. Ms. Phillips, the child's mother, said, get the child to the hospital. Mr. Little did not call 911. He, in fact, endeavored to load the child up into a vehicle. At some point, approximately 9 minutes later, they arrive at the Fort Walton Beach Hospital. Do not go directly to the emergency room. In fact, drive for a period of approximately 2 minutes and 45 seconds around the entirety of the parking lot, park, reposition the car, and then get out holding the child. He and the child's biological grandmother, who met Mr. Little at the hospital in order to take Levi for medical treatment, walk into the emergency room with a child that is being held and is blue. The hospital immediately calls the code. They rush the child in the back. His heart had stopped. He was not breathing. They were able to resuscitate him enough to get a heartbeat, but for all intents and purposes at that point, the child was brain dead. Once the child is in the emergency room, medical personnel immediately report to the sheriff's office that they have an incident of suspected child abuse based on how the child presented. There were marks on his neck that were consistent with scratch marks. There was a large bruise on the left side of his chin. There was also small petechiae that were forming in the area of his neck. Once they were able to get the child stabilized, they had spoken to Mr. Little, who admitted being alone with the child, who said that he had fallen on the child. Law enforcement begins to suspect that that story is not at all consistent with the injuries that are occurring in Levi Phillips' body. The child ends up being transported to Sacred Heart, where he stays in a essentially brain dead state until he is pronounced dead on June 10th. An autopsy was performed. During the autopsy, Dr. Lesky provided a report in which there were rib fractures in the child in stages both acute that occurred on June 7th and subacute that were healing. There were also compressions, fractures of the child's spine that she had never seen in a child that age, both acute and subacute healing. The hemorrhages that were to the child's brain showed profuse bleeding, both subdurally and subarachnoid. There were hemorrhages to his spinal cord. Essentially, Levi died as a result of complications from blunt force trauma. It was ruled as complications from blunt force trauma because they had kept the child alive in order to harvest his organs prior to his death. The cause of death was related to blunt force trauma. In the hearing that we had before Judge Brown, he did determine that the state had met the burden regarding the substantial proof of guilt of Mr. Little, but he did note for the record that Mr. Little did not have a prior history outside of this case. And while we were waiting for information to come back from the autopsy regarding testing that was done to Levi's organs, there had not been any criminal actions that had occurred resulting in any kind of arrest while he was awaiting his arrest on these charges. Based upon that, Judge Brown had set the bond at $1 million with a number of terms and conditions regarding contact with the child. What we are asking is for the court to adopt that $1 million bond based on the facts and circumstances. He is now charged with a capital offense, which is first-degree felony murder, as well as aggravated child abuse. Levi's family is present with the grandparents and I believe great-grandparents today. I was also provided a letter from his mother, Haley Phillips, who is not present, but they did ask for me to read that to the court, and I provided that to Mr. Klein's to review. That's okay. Charles Little has ruined my life. He has robbed me of every ounce of happiness and joy left, of not just one, but both of the two beautiful children I had. The only two things that brought true color to my world. His actions cost me my 1-year-old son, Levi. They also caused a domino effect of my daughter being wrongfully taken away from me. She no longer gets to see any of her family who miss and love her dearly. We will never get to watch my son grow up happy and loved, but also we will miss out on my baby girl doing just that. I will never be able to trust again. I will never be able to know true happiness or peace in this lifetime. I hope he gets the worst outcome imaginable so that maybe him and his family can feel even a small fraction of the pain and suffering this has and still causes. He is a wolf in sheep's clothing. He betrayed our trust and destroyed our lives. I hope and pray that my son receives the justice he deserves and then some. And that's our position, Your Honor.
Your Honor, at this time, we will not object to the $1 million bond that's previously been set. I can tell the court in full candor, probably am going to ask the court to consider a bond reduction at some point in the future, but to be completely candid, I didn't even know this case existed until last Friday at about 2 o'clock in the afternoon. So then that's when I believe I was appointed last Thursday. As of right now, we are okay with the $1 million bond. I will not concede any culpability on anything that was just said by Ms. Herndon. I don't know how the court wants to proceed. I can tell the court that Mr. Little is on the 1:30 docket, so if the court wants to take the arraignment also at the end of this, I think that'd be best.
So procedurally, let me be certain I understand where we are. The predecessor judge had a pretrial detention. It went with this. The state went forward with that, and the court found that the factors established pretrial detention had not been met, but the court established a bond. We're now back because after the indictment was issued, the defendant had a subsequent first appearance, which the law requires, and as a result of that, under the provisions of the statute, it was set again by the first appearance judge for another pretrial detention. It's the state's position at this time that they do not seek to go forward with a formal pretrial detention and present evidence, but wish the court to adopt the prior findings and continue the bond that was previously set.
Yes, sir, that is
Okay.
correct.
And so I can clarify the record a bit, Your Honor. At that hearing that occurred on December 26, Mr. Little was represented by Mr. LaPella and Mr. Rare, I believe.
That is correct.
Okay.
So the reason I went through all of that is I think this, I'm not certain that this proceeding is actually required pursuant to the statute as I understand it. I believe that the process that we have in place is there to assure that no case potentially misses the requirements of the statute as the court understands it. And therefore, the court would ask that the two of you collaborate to simply indicate that the state has not brought forward any additional evidence regarding pretrial detention, and simply that this court confirms after the issuance of the indictment the bonds previously established by the predecessor judge and the pretrial conditions that the predecessor judge established.
Yes, sir, and I will prepare a proposed order, provide that to Mr. Kleins for review, and if acceptable, we will submit that through the e-filing portal to your honor.
So with the first pretrial detention hearing, there was only one count. There is now 2 counts in the case.
Aha, thank you, Madam Clerk. So thank you, Madam Clerk. So the original count that was before the court on before was let me see.
And the way that it's termed, it effectually was aggravated manslaughter of a child.
Right, and so it's actually a different charge, correct?
Yes, sir.
And it was the single charge.
Yes.
And now we have the all right. So actually that would be incorrect, wouldn't it? The state does not go forward pretrial detention. The court will establish on the homicide, willful kill, murder, premeditated, $1 million bond. On the cruelty on child, aggravated battery on the child, which is the second count, which is a first-degree felony, the court will establish $500,000 bond, same pretrial release conditions that were previously established by Judge Brown regarding any contact. The court will additionally, and let me just double-check that order again. And Madam Clerk, where is the bond order itself? I don't see that.
And if I may approach, I do have a copy of the bond order in writing.
Docket 20.
Thank you.
And so those conditions would be pretrial services, standard conditions, plus the provision for weekly reporting, no contact with any of the victim's family, not be within 500 feet of the victim or any of the victim's family, residence, vehicle, employment, or places frequented by the victim's family. There must be GPS attached before leaving the Okaloosa County Jail, and the conditions on that would be similar to house arrest sanctions. So that would be the highest level of pretrial supervision available should the defendant make the bonds involved. And since we have an unusual set of circumstances, that's the reason I'm asking the two of you to collaborate as opposed to using the form order that we have.
Does the court want just one order entailing everything we've done?
Yes, I think so. We, as you know, we've adopted the two forms simply because trying to cover the circumstances, but a single order providing for those findings and adopting the pretrial conditions would be sufficient for the court.
Yes, sir. As to the actual arraignment of Mr. Little, if the court would allow me to acknowledge receipt of a 2-count indictment, I will waive the formal reading. I have provided Mr. Little a paper copy of the indictment. We will enter not guilty pleas. And I discussed with Ms. Herndon, I think given the serious nature of this allegation and the fact there's probably going to be a lot of medical doctors involved, or medical personnel, I should say, involved, I believe a request to continue this, Mr. Little will waive his speedy trial rights and ask that this be continued to the July docket for a status conference, just so the court, we can update the court on the progress of the case toward a resolution.
Is there an objection to moving it to the July docket?
Yeah, Your Honor.
All right. Now, the only condition I have, and you know this is what I've been doing in these cases, that's a substantial period of time. I know is a lot in the case, but I'm going to require the two of you to at least collaborate and present to me something which suggests how you're going to move the case forward. Now, I'm not, at this point, since it's so early in the case, I'm not going to require that you specify the times of the depositions and everything, but I would say that before what I would like to do is we'll put it on for April, not for appearance. That date, what's our date in April? 4/17?
Yes, sir.
For a status where I would like y'all to come back, and I want you to be prepared on 4/17 then to present to me an order which is a scheduling order of how we're going to do the depositions, what we anticipate based upon them. By then, we should have a substantial amount of the discovery ready and have an idea of looking at the timing. And if with that timing and understanding Mr. Klein's time and the state's time, if it's not realistic for July, then why bother to leave it on the docket for then? Let's look at that. Let's figure out the dates and set a schedule for moving the case forward to a conclusion in the most expedited way. So we'll set that on 4/17.
Okay.
Expect you to come back and report what you intend to do, and then we'll do that in the form of a scheduling order, which says how the case is going to progress towards disposition, considering the nature of the case and the complexity of it.
And given the seriousness of the allegations here, Your Honor, I would suggest that, at least as of right now, that Mr. Little be transported on April 17th, so he is present for that.
Absolutely.
If he wants me to file a waiver, I will put in writing that I have consulted with him and he does not wish to be present.
Absolutely. At this point in time, although it's a status because of the nature of the charge, he'd be transported. I leave that up to you in consulting with him whether he desires to have that waived and have that agreement made.
Yes, sir.
And if you anticipate, based upon your discussions, that it will result in continuing the trial date, then I would prefer to have him here to announce his understanding of that on the record based upon your present waiver of the speedy trial. I just want to be sure that there's no questions about that and he participates meaningfully in the scheduling order so the case moves forward.
I typically believe that defendants faced with any type of first-degree murder case should be in court every time that their case is discussed personally. So I will consult with Ms. Herndon, and we will get the court up to speed as quick as we can.
All right, very good. All right, and so we'll expect an order then, Ms. Herndon, and you just pass it by Mr. Kleins and then submit it for my execution on the bond.
Yes, sir.
Okay. All right, so we'll set it for the July trial cycle, but a status on April 17th. All right?
Is that at 9 o'clock, Your Honor?
Yes, sir.
Okay. All right, I'll come to jail, we'll talk. Okay.
We'll take Taylor. Correct. He may be transported if that's available.
Good afternoon, Judge.
Good afternoon.
This is Mr. Sonny Taylor before the court in 25 CF 279. We're here for a pretrial detention hearing and speaking with the state. I don't believe that the state intends to present evidence.
State.
Not moving forward for pretrial detention hearing. That's correct.
And there have been negotiations with the state as to the proper bond amount in this case.
All right. Go ahead.
I believe that the agreement is $25,000 cash or professional.
Yes, sir.
Now, is this a one count or a two count?
It's a two count. We have the first degree and we have a POP as well.
Judge, I believe the $25,000 count would be in the trafficking case. I believe that the agreement calls for pretrial services with weekly urinalysis, and I believe house arrest sanctions to reside at his mother's address. That address is 35 Old Cypress Circle in Fort Walton Beach. His mother and grandmother are present in the courtroom. They've confirmed that that address is good and that he is welcome and stays at that address. I would note for the record that Mr. Taylor is currently 19.
And that's the agreement with the state. That's the stipulation. As to that misdemeanor count, the $1,000 signature bond.
The defense would be fine with that.
All right, so pretrial services, standard reporting conditions or enhanced reporting?
We just want to make sure if the standard would still allow for the weekly drug testing, then that would be fine. But if we would require that enhanced, then that's what, we just want to make sure he's tested regularly.
All right, so weekly reporting and so you did say GPS or not?
Judge, GPS was not discussed with the state, but I'll defer to the court.
Well, if you didn't have an agreement, then I'd have to hear testimony, but you want substance abuse, substance testing, right?
Correct.
Yes, Your Honor.
And pretrial services are able to do the house arrest sanctions, is that correct?
Correct.
Okay.
All right. All right, so let me confirm, we got $25,000 cash for professional on count 1, $1,000 signature on count 2, pretrial services, weekly reporting, which has the standard conditions, plus random drug testing and house arrest sanctions, right?
Yes, sir.
Yes, Judge, and the state wanted to make sure that he resided at his mother's address, which was the address stated.
And that's the Cypress.
35 OLDE Cypress Circle, Fort Walton Beach.
Okay. Anything else?
No, Your Honor.
But you bond out. Okay, then the court. Okay. Let me know that you're out. We'll stop the time to sit down and talk.
Does the court require an order?
I've just signed them.
Melissa Sloan?
Judges, Miss Melissa Sloan in 25 CF 307. Yes, Your Honor. Speaking with Mr. Snell, the state is not moving forward with the pretrial detention.
That's correct.
And ultimately, the bond is going to be set at $125,000 cash or professional, and I do have the breakdown for each count, Judge.
Stand by. All right, go ahead.
Yes, Your Honor. It's going to be for the 4 grams to under 30 kilograms for drug trafficking will be $50,000 cash professional. Drug equipment possession or use.
Slow down now. I can't
sorry,
type
Judge.
that fast.
Sorry, Judge.
That's okay. All right, so that's count 1.
Yes, Your Honor.
Count 2 is POP.
Yes, Your Honor. And that is going to be $2,500 cash professional.
Count 3 is amphetamine or methamphetamine 14 or over.
That's going to be $50,000 cash professional.
Count 4 is POCS.
Judge, that's going to be $20,000 cash professional.
And then count 5 is resist without violence.
And that will be $2,500 cash or professional.
Any special conditions?
Not similar to the last.
No pretrial services,
Well,
just,
pretrial services, yes, but not the weekly.
okay, so
Yes,
pretrial
pretrial
services, monthly reporting by phone?
Yes, sir.
Okay. And any special conditions other than that on pretrial services?
No, sir.
All right. And that's the state's agreement in this regard.
That's correct.
The state does not intend to proceed forward with evidence regarding pretrial detention in this matter.
No, sir.
All right. Very good.
Thank you, Judge.
Thank you. And I've signed the orders, and Fran should be loading them shortly. I mean, filing them.
Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking
This will be case number 2018 CF 1070. Thank you. This is Mr. Tate Smith in 2018 CF 1070, Your Honor.
All right. Go ahead.
Yes, Your Honor. This will be an admission. It'll be an adjudication of guilt. There is a sentence of 73.9 months, Department of Corrections. The state attorney stipulates that Mr. Smith has credit for the 73.9 months DOC, ultimately making this a time-served offer, Judge. There's the $100 cost prosecution. There's the $150 in defense costs. Probation will be revoked and terminated. All counts to run concurrent. And there is the $190.80 for that prisoner transport.
Yes, sir. Yes, sir.
If I may approach the signed plea form, Your Honor, and Mr. Snell will get a score sheet in this matter.
You may. Okay, raise your right hand for me, please.
Yes, sir.
Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Well, you can put your hand down. You heard what Mr. Koch said on your behalf, and you signed the written plea form.
Yes, sir, I did.
All right. You understand that you're admitting the violation?
Yes, sir.
And that says to me that, Judge, I violated my probation just the way the affidavit report filed by my probation officer says it did.
Yes, sir.
And do you understand by making this plea, you're waiving your right to a trial where the state would have to prove your violation?
Yes, sir.
And in this case, you have been previously adjudicated guilty of these charges, and you're going to be sentenced to 73.9 months in the Department of Corrections, with your probation to be revoked and terminated. All counts to run concurrent. You'll have the additional $100 cost of prosecution, $150 defense cost, $190 cost of transportation, and you also have some outstanding fees and costs. Looks like about $650, Madam Clerk. $660. $665 fees and costs. Now, you'll be given credit for all time served. The state stipulates that you've got credit for the 73.9 months in this case, so it should be a time served sentence.
Yes, sir.
How much time do you need to get all your fees and costs paid after you're released?
6 months to 1 year, I mean, would be agreeable if possible, Your Honor.
Okay, 1 year to pay. As long as you're making payments, if you need more time, then all you need to do is ask, and I'll give you more time to pay.
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea with a prior adjudication.
Okay, thank you, Your Honor.
Thank you.
Yes, sir. Thank you. All right, Mr. Smith. You're welcome. All right. Yeah, we'll need a score sheet.
Yes, sir. I will submit one.
All right. There are a couple of folks in the gallery. Anybody that y'all can quickly reach out to and see if they're your folks, and we get them moving on their way, even though we're a little early.
Judge, if possible, Madam Interpreter is here. I know she has another case in Judge Clark's room. If we could address Mr. Gabriel Reyes, if possible.
Gabriel Reyes. And if you'd raise your right hand, please, Madam Interpreter, you swear to interpret these proceedings truthfully, adding nothing and subtracting nothing.
I do.
Thank you.
Thank you.
And so can you get over him and put it on Reyes?
Thank you for coming here. Very quick, yeah. Judge, this is Mr. Gabriel Reyes in 24 CF 2929. Judge, receiving the information, will be entering not guilty, waive formal reading, and request it be kept on the March pretrial docket, Judge.
Objections to advancing, leave it on that docket, State?
No objection.
All right. Thank you. Anything else for you, Madam Interpreter, on this docket?
I have to come back at 2:30, so I'll be back.
Okay, thank you, Madam Interpreter.
One individual in the courtroom that may need the services of the interpreter.
Who is that?
Mr. Darwin Roman. I didn't see him on the docket.
Okay, if you, Madam Interpreter, if you engage and get him up here, please. What's his name?
Sí.
¿Necesita ayuda de jefe? Pase, por favor.
I don't think his hands are as pockets, thank you.
Por favor, señor. Fuera de bolsillo.
What, Mr. McKinney, do you have a case number, or?
I don't, Judge. His last name is, I believe, Roman, R-O-A-N. First name Darwin.
Madam Clerk, any help?
With that common spelling, I'm not pulling anything up.
¿No están encontrando su nombre en el estado? ¿Usted cree que tenía corte hoy?
Sí, hoy a las 1:30.
I was scheduled to come in today at 1:30.
May I have the spelling of the last name?
¿Cómo se
Hágame
pronuncia?
por favor.
¿Qué pronuncia?
Aquí tengo mi pasaporte.
So last name would be Banegas Roman, B-A-N-E-G-A-S hyphen R-O-M-A-N.
And first name?
Darwin, D-A-R-W-I-N. Middle name Goevin.
I found it. He was on the docket with Judge Clark, but the case was no cost.
Estabas en el estado para la juez Clark y tu caso fue desestimado. Sí.
Entonces todo.
So is everything okay?
Yes.
Pero en mi caso no me hace.
Can I go home? Nothing's gonna happen?
The case has been dismissed by the state.
Ok, gracias.
Thank you.
I have 3 present in the courtroom, Judge.
Say again?
I have 3 present in the courtroom if I may call them.
You go ahead, Mr. Cox.
Judge, I'll first call last name Rushing, first name Justin. We have 2 cases, 25 CF 97, 25 CF 183, Your Honor. Thank you.
Okay, I just see the one case. Do you see 2?
No, sir, we'll see.
I see 2597. You have another case?
25 CF 183.
That one is set on the March figure.
Well, let's bring it forward then. Has the information been filed?
Yep. Yes, sir.
No, sir.
What's the case number again?
25 CF 183.
No information has been filed in the 25 CF 183 case.
And then ultimately, Your Honor, in the 25 CF 97 case, I believe it was found that my client was not indigent. I believe that's reported in the top of the file.
So you have 3 dependents plus yourself living in your household?
Yes, sir.
To me. It looks like the disqualification was based upon the total income. So that was my question. You have 3 people that you're required to support plus yourself, right?
Yes, sir. I have 3 children.
And is that a fixed income that you get? Is it hourly or is it?
It's kind of, yes, like a set wage every week.
And that's what you take home, or is that your gross?
That's what I take home.
Okay. We're just double checking something real quick. All right, well, what I'm going to do is I'll accept the not guilty plea in this case, and we'll set the case and the other case for the May docket, and we'll make this inquiry here, and on this basis, provisionally, I'll find him indigent, and if we get an answer to the question that I inquired based upon the application and the clerk's finding, then we can address it in May.
Yes, Judge.
I do have an answer. It is only for the dependents. That's what the asterisk means, is dependents only.
I'll find him indigent under the circumstances presented and qualified to be represented by the Office of the Public Defender.
Yes, Judge.
Okay.
And did you state for them all to be set in May?
Yeah, when did they say?
Well, they're both set on the May pretrial conference docket, but the other case is on the March felony plea day.
Yeah, we'll leave the other one on March felony because there's no information filed yet.
Yes, Your Honor.
Okay.
What's the date in May, ma'am?
For pretrial conference,
Yes,
May
ma'am.
12th.
May 12th, okay.
And Madam Clerk, can I ask for that March date?
Yes, March 13th.
March 13th. Thank you.
You're welcome.
So you'll have to come back March 13th, same time, 1:30, to address that other case number, okay? Okay. So you can feel free to call us for an appointment. Yep, absolutely. Take that one. All right. Yes, sir. And Judge, I have some more in the courtroom if I may call.
Yeah, go ahead.
Thank you. I got Mr. Mark Stupar, S-T-U-P-A-R, in 24 CF 2900.
Mr. Stupar.
Good afternoon.
Good afternoon.
Judge, I believe the information has been filed. Thank you, Deputy. Receiving the information in front of us, Your Honor, will be entering not guilty to all counts, waive formal reading, and request that this be kept on the March pretrial docket, Your Honor.
All right. Now, do we have correct information for you, Mr. Stupar, as far as your phone, email, and all that? There's a form there for you to complete. Fill that all out. That gives the clerk what we need to be sure to be able to contact you and turn it into the bailiff before you leave, okay?
Sure.
Okay. So you can have a seat to take this. Excellent. And next, if I can call Mr. Dante, last name Simpson, in 24 CF 2936. Mr. Dante Simpson, who is present and approaching, Your Honor. Your Honor, I checked this morning. I know information has been filed for Mr. Simpson. Mr. Simpson.
All right, thank you. Is it on page yours?
Yes.
Information was filed 2/12.
Thank you. Your Honor, we'll be entering a not guilty, waive formal reading, and request that this be kept on the March pretrial docket, Your Honor.
And Simpson, for you as well, there's that form. I want you to fill that out, which has a full address, phone number, and email, that makes certain that the clerk has what they need to send you proper notices of hearings and be in contact, and gives your lawyer the same information. So fill that out and turn it in to the bailiff before you leave today, okay?
Yes, Your Honor. Yes, sir. I'll do that.
And if I could pass up the remainder to...
Your Honor, I have Chelsea Miller.
Miller?
Yes, sir, on the arraignment docket. You there?
Yes.
Okay. Your Honor, this is Ms. Miller. We will acknowledge receipt of a 2-count information. We will waive the formal reading, enter a not guilty plea. Looks like she's already on the May 12th docket, if we can just leave her on that docket.
All right, same for you, Ms. Miller. If you'll fill that form out with all the proper information and be sure to pass it back to the bailiff before you leave today, that helps the clerk and your lawyer stay in touch, and be sure you get all your notices, okay?
Thanks, sir.
There's also the QR codes up there, Mr. Kleins?
Looks like I just have PD applications and next court date notifications.
Judge, may I approach real quick? It's just me. It's not on this case.
Yes, sir.
Your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy.
Beth
here in
Parsons, are you
Crestview.
present?
We have been serving the area since 1999. We're an alternative health food
So she's
store.
not present.
If you're interested in bettering
Okay,
your health,
all
we'd
right.
like to invite you
Why
to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Well, we're gonna do a Zoom.
I'm Amanda Gaskin with Ryder Press Realty.
Sorry about that, Judge.
It's all right.
Hey, Lynn.
Mr. Cobb, are you there with us?
Yes, sir, I am.
All right. Your client, Ms. Wycheck, is present.
Yes, sir. Judge, I was recently appointed to represent Ms. Wycheck. I went to the jail and I spoke with her about possible ways to try to resolve the case. I haven't had a chance to talk to Mr. Snell yet about the case and or even get the discovery from her former attorney. It's just early days for me in this case, but I was hoping that I could come up with some type of resolution so the case wouldn't drag on any longer than it has to. So if I can get a control date, I don't really necessarily want to pass it a full cycle, but I just need a control date so I can talk to the state.
You want to put it on for 3/10, Mr. Cobb, which is our,
Yes, sir,
which is our
that'd be
next full trial cycle, and that should give you enough time to get it done.
And if I can get something early, I'll advance on the docket.
Absolutely. Our next date is 2/20, and we may have a couple of other dates in between. So if you get a resolution, particularly concerning the reports that I've read, it's important that we get a resolution as quickly as possible in this case. So work on it as best you can, and if you get that resolution, you know my policy. If I'm here and I get a courtroom and a clerk, I'll take that plea and resolve the case anytime.
Yes, sir. Thank you, Judge.
Okay. You have any questions, ma'am?
No, sir.
Okay. All right. So
Thank you.
we'll leave it on for control for 3/10.
And then, Your Honor, while we have Mr. Cobb, if we can go ahead and at least take care of Mrs. Parsons'
Yeah,
cases.
Mr. Cobb, Ms. Parsons was here earlier, but she had a medical episode and had to be transported away from the courthouse. So we'll reset her for
Can we track the VOP cases with the new law, which is set for 310, Your Honor?
We'll track the VOP cases with the new law on 310 as well, Mr. Cobb.
All right, Mr. Gomez, I didn't know, I know she has a prior case, possession case, but I didn't know it was a VOP. I thought it was 2 new cases.
Maybe that is it. Hold on.
Yeah.
I thought
So
it
we
was
can leave them
miscellaneous.
both on.
Yeah, I'm sure they're both new.
Okay, they're both, okay, sorry about that. Then, we should track all of them with the 310 cases.
But we were here
That'd be
today with
great.
Ms. Parsons. What were we here then on?
That's what I thought.
Miscellaneous docket?
I think that was just set for miscellaneous to see if we could potentially get a plea together.
So
maybe.
we'll leave it on for 310. Hopefully you'll be able to take care of her when she's back.
Your Honor, the 25
All right, thank you,
CF
Judge.
case is on felony plea today.
Okay, 25 CF felony plea day. You waive formalities and enter not guilty?
Yes, sir, I filed a written plea of not guilty today, but yeah, I would enter a written plea of not guilty. That's the 2596 case, correct?
Yes, sir.
Okay, yeah, that's right, not guilty.
All right, we'll leave it on for the 310 then.
All right, thank you.
Thank you. Take care. Take care.
Thanks.
Your Honor, I have somebody in the gallery.
Go ahead, Mr. Kleins.
Kirsten Mann.
Say again?
Kirsten Mann.
Man.
Yes, sir, this is 25 CF 23. Your Honor, this is Ms. Mann. We will acknowledge receipt of a 2-count information, waive the formal reading, enter a not guilty plea. Ms. Mann does have another case, 24 CF 1944. That case is already on the March 10th docket. This new case is also going to be placed on the March 10th docket. However, I can tell the court, last week, Mr. Gomez and myself took depositions of pretty much witnesses that cover both cases. As of right now, Ms. Mann's going to stay on that March 10th docket, but I am going to talk to her, and there's probably a pretty high chance that she's going to be back before the court next Thursday for entry of an early plea to avoid the rush on March 10th, if at all possible. So if that's the case, I will file a notice of hearing so Madam Clerk can prepare a minute sheet.
Okay. Anything changed on your information since you previously gave the clerk all of the information about your emails and everything?
No, sir.
Okay, very good. All right, so we'll reset this and then expect if you need it, you can be back on the 20th.
Yes, sir.
Okay, thank you.
Judge, I have Julissa Thornton.
Thornton, please.
She is present before the court in 25 CF 8, here for arraignment today. The state has filed an information. We would acknowledge the receipt of a 1-count information, waive its formal reading, enter a plea of not guilty. Madam Clerk, is this scheduled for March 10th?
Yes.
I'd like to leave it on that date.
All right. And Julius Thornton, if you'd complete that form as well with all the information, that'll be certain that we have the information needed for the, oh, you already did?
Yes, sir.
Good, thank you, Mr. McKinney. All right, we'll see you on 310. Stay in touch with Mr. McKinney. Thank you, good day.
Let me get you one of my cards.
Anybody else? Then Mr. Kleins, I see Tawan Lee is on for you and also with no attorney.
Yes, Your Honor.
Huh? It's a TR case, but I think,
This is a traffic citation. We're going to merge and dismiss the traffic citation.
There's going to be a plea.
It's going to be a plea, Your Honor.
okay.
And so just so that we can get everything off the docket and make sure it's taken care of, the state would just merge and dismiss the traffic citation. when we
Okay,
lay that
we'll
out.
do that when we get there. I just trying to update, be sure Mr. Kleins was aware of
I
that. when
appreciate
was
that.
looking at that.
I would have totally missed that.
I believe it is a court mandatory, like the benefit action.
Mr. Gomez, if you'd approach with Mr. Kleins real quick.
Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday.
Go ahead, Mr. Kleins.
Your Honor, this is Mr. Lee in 24 CF 2903. He is here for arraignment. He is executing a plea agreement right now. So at this time, Mr. Lee will be entering a no contest plea as charged on all 4 counts here. Counts 2, 3, and 4 are all misdemeanors. Mr. Lee is going to be placed on 2 years of probation for count 1, that is fleeing and eluding. As a condition of probation, he will perform 24 hours of community service. There is a mandatory 1-year driver's license revocation. Counts 2, 3, and 4 will be sentenced to time served. He would be assessed $615 in court costs, $150 in public defender fees. He would be adjudicated guilty. Should we sign it? May I approach?
Granted.
The court costs for the plea and elude will be $648.
$648?
And that's the state's agreement?
That's correct, Your Honor.
All right. Raise your right. You need a minute, Mr. Lee?
Sir?
Do you need a minute to ask a question with your lawyer?
Sorry, no, sir.
Okay. Well, because it's important if you've got one, you have it answered.
It's okay.
Okay. All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Klein said and you signed the written plea form?
Yes, sir.
How old are you and how far did you go in school?
27, and I graduated with a 3.9. I made
All
the
right.
rules for it.
You able to read and understand the plea form? Did you do that before you signed it?
Yes.
And is what you read in the plea form what Mr. Klein's just announced to me?
Yes, sir.
All right. Do you understand by this plea agreement that you're pleading no contest to these charges?
Yes, sir.
And that says to me you believe the state has the evidence to prove your guilt and you're not going to contest that?
Yes, sir.
Do you understand by making this plea you're waiving your right to a trial where the state would have to prove your guilt?
Yes, sir.
In this case, you'll be adjudicated guilty. You'll be on 2 years of probation with some community service, a driver's license revocation, and on the other counts, it'll be time served, and you'll have some fees and costs to pay during your probation in addition to the standard terms and conditions of probation. Is that what you understood?
Yes, sir.
Has Mr. Klein's answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how Mr. Klein's has represented you?
Very much so.
I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea.
Your Honor, would the court consider merging and dismissing the traffic citation in this case?
The traffic citation in 24 TR 13703 is merged and dismissed.
All right. They're going to fingerprint you and then report the probation if you get out before 5 today.
That is within adjudication. If you'd step this way and have your prints made, sir, but before you leave the courtroom, probation's going to give you a notice for you to report as soon as you can to their office.
Okay, so over here first. Philip Lazinski, to the left.
This is just an arraignment. Your Honor, this is Mr. Lazinski. In 25 CF 161, we will acknowledge receipt of a 5-count information, waive the formal reading, enter a not guilty plea. Mr. Lazinski's case is already set on May 12th. I can tell the court that I will fully intend to be filing a motion to reduce bond in this situation. So my intent is to have Mr. Lazinski back before the court, hopefully by next Thursday. But as of right now, if the court can just leave this on the May 12th docket.
State.
Judge, we have no objection to the May pretrial continuance, and we'll await a motion to respond.
Is it?
It's already on, I believe it's already on the 12th.
On which one? May 12th? Yes.
Yeah, it's currently set on the May 12th.
Yes, we can just leave it on that date, Your Honor.
All right, and so, but you waive and it's a not guilty.
Correct.
And we'll leave it on. Okay, very good. Thank you.
All right, man. I'll get that bond motion filed as soon as I can. Yes, sir. Go ahead.
Next will be Ontario. Ontario Murray.
Sorry. Your Honor, this is Mr. Mari in 24 CF 2928 and 2923. Mr. Mari is signing a plea agreement to dispose of both of these cases at this time. Today, Mr. Mari is going to be entering a no contest plea as charged in both cases. The agreed upon disposition is that Mr. Mari will be sentenced to 90 days, Okaloosa County Jail, credit for all time served, concurrent to all counts and cases. He would be assessed $615 in court costs times 2, one for each case, a $50 application fee, 2 $100 public defender fees. He's previously been adjudicated. May I approach?
Granted. State.
That's the agreement, Your Honor.
Raise your right hand for me, please, sir. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay. You can put your hand down. You heard what Mr. Klein said, and you signed the written plea form?
Yes, sir.
How old are you and how far did you go in school?
46, 11.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what you read what Mr. Klein said?
Yes, sir.
Do you understand that you're pleading no contest to the announced charges in this case?
Yes, sir.
And it's two cases, 2-3 and 2-8, correct?
Correct, Your Honor.
Okay. And by pleading no contest, what I understand you say is you believe the state has the evidence necessary to prove your guilt and you're not going to contest that.
Yes, sir.
And do you understand by making this plea, you're waiving the right to a trial by jury where the state would have to prove your guilt beyond a reasonable doubt?
Yes, sir.
And in this case, you'll be adjudicated guilty. You'll have the court costs that were announced. You'll be sentenced to 90 days in the county jail, credit for time served. Mr. Klein's answered all your questions about the plea and how it affects you.
Yes, sir.
You satisfied with how he's represented you?
Yes, sir.
Now, you've got some substantial fees and costs to pay. How much time you think you'll need when you get out of jail to get those paid?
I have a job waiting on me. I just gotta get out and just go talk to a cousin of mine, and hopefully I can start work right away. So,
Think a year will be good?
that would be fine.
Okay. I'll give you a year to get your payment, to get to pay, and as long as you're making payments, if you need a little more time, all you need to ask, and I'll give you additional time. If you're not making payments, I won't give you any more time. You understand?
I understand.
Okay. All right. Court will find the plea to be freely and voluntarily entered into. Will accept the plea with the adjudication. If you'll step this way, please.
Next will be Scott Knowles.
Scott Knowles, please.
To the left.
Your Honor, this is Mr. Knowles. I don't know if he actually went through arraignment. I know he was on the January 16th arraignment docket, but there was a medical situation. He wasn't actually here. Regardless of what happened, I will go ahead and acknowledge receipt of a one-count information. We are going to be entering a no contest plea to that information. The agreed-upon disposition is that Mr. Knowles will be placed on 18 months of probation. He will pay $1,960.14 in restitution to First Florida Bank. He will also have no trespassing at First Florida Bank. Probation will automatically early terminate upon payment of restitution in full. He would be assessed $615 in court costs, $150 in public defender fees. He's previously been adjudicated. If I may approach.
Right, so the termination is upon payment of the restitution. What about his other costs? The only reason I say that, Mr. Knowles, is I don't want to set a trap for you, because you pay your restitution, you get terminated, and you don't pay your cost, then those costs have a consequence for you as well.
Mr. Knowles has indicated he would be willing to modify that to automatic early termination upon payment of all financial obligations.
Yes, sir. Okay. All right, so we'll modify that to payment of all restitution and, all right. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you put your hand down. You heard what Mr. Klein said, and you signed the written plea form?
Yes, sir.
How old are you, and how far did you go in school?
55, and I graduated RTC and 17 years old.
All right.
Alabama. I'm a veteran.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what you read what Mr. Klein's announced to the court just a minute ago?
Yes, sir.
Do you understand by this plea agreement that you're pleading no contest to the charges?
Yes, sir.
And by pleading no contest, I understand you to say you think the states can prove your guilt and you're not going to contest that?
Yes, sir.
Do you understand by making this plea you're waiving your right to a trial where the state would have to prove your guilt?
Yes, sir.
In this case, you'll be adjudicated guilty. You'll be on the 18 months of probation with the restitution and the fees and costs. And were those correct, Madam Clerk, with the theft? Okay. With the fees and costs that were announced. And if you pay all your fees and costs, then you can early terminate, assuming you have no other violations.
Yes, sir.
In addition to the standard conditions of probation. Mr. Klein's answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how he's represented you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into, and will accept the plea with the adjudication. You need to get your fingerprints taken, but before you leave the courtroom, probation is going to give you a piece of paper for you to report, so you need to be sure to take care of that and report to them as soon as possible, okay?
Yes, sir.
Thank you now.
So Anthony Patterson's next, unrepresented, I believe.
Good afternoon, Mr. Patterson. You're here today without a lawyer. Do you want a lawyer to help you?
If I did.
Say again?
I said, yes, sir, I do. I need a lawyer.
All right. Are you able to afford a lawyer on your own?
No, sir.
Okay. When's the last time you were employed, Mr. Patterson?
2020.
Okay. As I'm reviewing your application, and it was incomplete, it looks like you didn't sign it. Raise your right hand for me. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. So what I'm going to do, Mr. Patterson, is I'm going to project this form up here on the screen, up here, and I want you to swear to the truth of the matters in the form. And if you do that, then I'll appoint the public defender for you. You ready?
I can't read that good, sir.
Okay. Is that the form you completed? And you see there's no signature. I'm putting my cursor right here. You didn't sign right there, see?
Yes, sir.
Do you swear to the truth of what you've put in this form, even though you didn't sign it?
Yes, sir.
Okay. The court will find that based upon the in-court affirmation of the contents of the affidavit, the application, that Mr. Patterson qualifies for the appointment of the public defender, and appoint the public defender to represent him in this case. Now, Mr. Koch, you'll be appointed to represent Mr. Patterson in this case, which is a felony battery case, and we're here for plea today. And I believe the state has filed information on 131, and it's a one-count information, which, I'm sorry, it's two counts of information, which is two separate counts of battery, it looks like. And they're felony batteries based upon prior convictions.
Yes, Your Honor. Receiving the two count, I know There's alleged victims in here. Is there an offer at this time?
Adjudication of guilt, guideline sentence of 18.83 months in the Department of Corrections.
Thank you, Mr. Gomez. At this time, we'll be entering a not guilty, Your Honor, waive formal reading, and request it be kept on that March pretrial docket.
All right.
It's currently on the May 12th docket.
It's on the May 12th docket. You want to advance it?
Not at this time. We keep it on the May 12th docket, Judge, or the May
Okay.
pretrial docket.
All right, we'll leave it on that docket.
Okay. I just got appointed. Take this information. That was the offer that was just conveyed. And I'll talk to you at the jail. Yes, sir.
I'm sorry, Your Honor, was this set for May 12th? Thank you.
Salvatore.
And this is Mr. Cobb too, right? I think this is Mr. Cobb's cases as well.
Correct, Judge. The PD's office did withdraw from this case. I believe it
And
is.
so Mr. Cobb, I guess, doesn't know because I think I signed these orders yesterday. Right? Is that right, Madam Clerk? On the 4th. So I'm not sure he actually knows.
Your Honor, I would, for the sake of judicial efficiency, I would, I guess, recommend that I'll let Mr. Cobb know, and then we set these for 2/20. I mean, he does, if I'm not mistaken, the jail website wasn't working for me earlier, but I'm sure he was given a bond, and so I don't know if there'll necessarily be any negative consequences to resetting this on 2/20 to make sure that Mr. Cobb could be here.
Yeah, because there's a series of cases, and it looks like they were appointed in sequence based upon the withdrawals, and that Mr. Cobb's not here, but he has other circumstances where he couldn't be present. He was here earlier by Zoom, but I don't think he was aware he had your cases on the docket today. So we can continue these to 2/20, but I believe you already have bonds set in your first appearance.
I believe it was revoked.
Yeah, I'm looking at the jail website now, Your Honor. It looks as though, I don't know if he had, it looks as though bond was denied.
So we'll reset this on 2/20. Okay?
Tyler Richmond.
Judge, this is Mr. Tyler Richmond in 25 CF 31. And Your Honor, Mr. Richmond, this will be a change of plea this afternoon. Count 1 as charged. Count 2 is going to be the lesser included first-degree misdemeanor of petty theft, and that's Florida Statute 812.01, 4 subsection 3, subsection B Bravo. The terms will be adjudication of guilt, 60 days in the Okaloosa County Jail, credit for time served, court costs. There's 115 defense costs, all counts to run concurrent. If I may approach with the signed plea form.
You may.
This is a misdemeanor, Your Honor, so
All right, raise your right hand for me, please. Do you swear or affirm? Raise your right hand. Do Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand down. You heard what Mr. Koch said. You signed the written plea form.
Yes, sir.
You understand you're pleading no contest to the lesser included petty theft and the trespassing charge.
Yes, sir.
You're waiving your right to a trial. You'll be adjudicated guilty, 60 days county jail credit for time served, and you'll have court costs to pay, and those would be, Madam Clerk, how much?
270. And then the PD fee.
270 plus $150 cost of defense. How much time will you need to pay those after you get out?
Probably about 30 days.
You sure you can get that done in 30 days?
60 days. Just give me 60 days.
60 days to
Give me
pay.
60 days.
And if you need more time and you're making the payments, I'll give you more time, okay?
All righty. Thank you, sir.
All right. I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea with the adjudication.
Yes, sir.
Was it announced that count 2 was lesser down to a petty theft?
Yes.
I show count 1 is the felony petty theft. Count 2 is a trespass.
Okay, so that should be reversed. Count 1 is the lesser included petty theft. Count 2 is the trespassing. Thank you, Madam
Originally, it was
Clerk.
the other way around.
Thank you, Madam Clerk. So that's all good, yep.
All right, very good.
That's everything.
All the penalties.
Yep. Good luck. You're welcome.
Peter Ryder, you'll be next. Peter Ryder.
This is a Mr. Cobb case as well. We could probably put this one on 220 as well. I believe that will need to be done.
All right.
And I notified Mr. Cobb already of both of those, Your Honor.
Say again this defendant's name?
This is Peter Rybicki.
Okay. All right. All right. Your attorney couldn't be here today, so we're going to reset your case to 220.
Is there any way I could get a bond, sir? At least a reduction? I was bonded out, but then he took my bond from me and gave me like a $20,000 bond.
Yes, sir. Today is the day where we're handling the your plea to the case, and no bond motion has been filed.
Okay.
So you can talk to Mr. Cobb. Mr. Gomez has let him know about that, and so we'll see you back on the 20th.
All right,
Okay?
sir. Thank you, sir.
Thank you.
Joseph Slade.
Judge, this is Mr. Joseph Chalet in 25 CF 107, and this will be a change of plea, no contest this afternoon, Your Honor.
All right.
And then ultimately, it's going to be as charged, adjudication of guilt, credit for time served, court costs, and then there's the 150 defense costs, Your Honor. If I may approach with a signed plea form, and Mr. Snell will provide a score sheet.
Granted. And Madam Clerk, what are the proper fees and costs?
$615 and then $150 PD fee.
All right. Raise your right hand for me, please, sir. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Yes.
I'd like to approach defense counsel on this.
Sure. All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand down. You heard what Mr. Koch said on your behalf. You signed the written plea agreement.
Yes, sir.
You understand you're pleading no contest to the lesser included offense of misdemeanor petty theft,
Yes, sir.
waiving your right to a trial.
Yes, sir.
You'll be adjudicated guilty, sentenced to time served, with fees and costs $270 plus the cost of defense $150.
Yes, sir.
How much time do you think you'll need to get those fees and costs paid after your release?
I mean, as much as you can give me, sir. I was homeless and had no ID or phone or anything. I'm gonna have to start from nothing.
A year think you'd be good enough?
Yes, sir.
Okay, as long as you're making payments, if you need more time, you can ask for it. If you're not making payments, I won't extend the time, but if you're making payments, I'll give you more time, okay?
Yes, sir.
All right. Find the plea freely and voluntarily entered into. I'll accept the plea. Step this way to have your prints done, please.
You're good.
Joseph Shirley.
This is Miss.
I'm sorry?
Correct. This is Mr. Nathaniel Seaborn. That was Joseph Chalet. It's okay. So you had it just right. Okay. Well, the judge. And thank you, Your Honor. Just to be clear for the record, this is Mr. Nathaniel Seaborn, 24 CF 2712, Your Honor. Receiving the information, 2 counts, will be entered not guilty and waive formal reading, Your Honor, and request to be kept on the March pretrial docket.
All right. Thank you very much.
Thank you, Judge. Thank you, Deputy. One second. This is Amanda Shirley in 24 CF 2913, Your Honor.
Yes.
Your Honor, we did receive the information. We'll be entering not guilty, waive formal reading, and just to update the court, we did receive.
I see the motions. Did you receive a report?
Not yet, Judge.
I don't know.
Not today. We're still waiting on Dr. Zeman for that
Can you
report.
loan me out, Mike? Today? Okay. Not today.
It won't be today.
When will it be?
That's what me and the judge were discussing. Ultimately, Dr. Zeman has to come talk to you and give us a report.
And then I can go home?
We'll go from there, okay?
Okay.
Okay. All right, so we'll enter the not guilty, and it's currently set for 3:10. If something happens earlier, then you just simply let me know, and we'll have a hearing earlier.
Absolutely,
Okay?
Judge. Thank you.
All right, thank you now.
Amanda, take that with you, Amanda.
Gail Thomas.
You loan me out today? I can't call you.
And who is this, Bill?
Gail Thomas. We just skipped one on the list because one is big.
Okay. All right. Good afternoon. You're Gail Thomas.
Yes, sir.
You're here today without an attorney. Do you wish to have an attorney to represent you?
No, sir.
Okay. Do you think you can manage this case without the help of a lawyer?
I think so.
Okay. State, do you have an offer in this case?
Is this the only case holding you?
Mm-hmm.
It'd be 3 years, Your Honor, probation with substance abuse evaluation, a treatment, no consumption of alcohol or controlled substance without a prescription.
Adjudication?
Yes, sir.
Withhold or
It'd
adjudication?
be an adjudication.
Okay. Do you understand what that means?
No.
Okay. Those are some of those things, they're asking that you be adjudicated guilty of these charges. That could have some consequences. Those are the sort of questions a lawyer probably needs to answer for you. I can't answer how those consequences may affect you because then we get into personal information about you and your history, and I can't do that. I can explain to you what it means, but I can't answer questions about how it affects you because essentially then I'd be giving you legal advice, and that's against the rules. So I'd strongly suggest you consider accepting a lawyer to help you under the circumstances presented. How long have you been in jail this time?
Since December the 18th.
All right. The court will appoint the public defender to represent the defendant in this case. Now, while you're at the jail, I'm going to give you an application for the appointment of a public defender to take back with you. You're going to have to complete that at the jail and turn it into the jail, and they'll send it into the clerk. But I'm going to appoint them provisionally right now since you've been in jail for that period of time to represent you. But you still have to complete the application and turn it in, okay? All right. And they'll give it to you when you walk out and just take it with you, but be sure to turn it in at the jail, and they'll send it in to the clerk, okay? Okay. Did you hear the offer, Mr. McKinney?
I did, and as soon as I get a file open, I'll go discuss it with Ms. Thomas at the jail. Has a next court date already been set?
She's set for 3/10, but as you know, if I'm here and I can get a clerk and I get a courtroom, I'll take a plea. She sounds like she's ready to do that, but I think she needs to understand the consequences of that.
I will discuss that with her as next week.
Okay. Thank you.
Darren Taylor.
Judge, this is Mr. Darren Taylor. Mr. Taylor is before the court in 25 CF 100. This is set for arraignment today.
Yes, sir.
Judge, Mr. Taylor is in court for arraignment as stated. I believe the state has filed an information today, which is a 4-count information. We would waive formal reading of that 4-count information, enter a plea of not guilty, and ask for this to remain on the first available pretrial date. I would note for the record that Mr. Taylor has filed correspondence to the court indicating that he certainly does not wish to waive any speedy trial rights.
It's currently set for 5/12. We can advance it to 3/10 if you wish, Mr. McKinney.
I would. I'd like to advance this on the soonest
Madam
available
Clerk,
pretrial
advance
date.
this on 3/10.
We could go ahead and set the 4 cases he's in violation status. You want to do VOP evidentiary hearing? Go ahead and get that started if you'd like.
What are those 4 cases so we can get them to run together, please?
Yes, Judge, 2019 CF 291, 2021 CF 250, 2022 CF 2182, and 2022 CF 1746.
And Reports, affidavits, reports, and a warrant have been filed in those cases already?
I've looked at the, there's an affidavit filed.
I guess I just trying to say I don't want to get the cart before the horse if we set them and he hadn't been served, right?
Madam Clerk, are all those cases open?
Yes, sir, they are. They were on the docket for January 23rd during, I believe, like the snow, and it just fell.
And so formally, I'd enter a denial to those violations of probation. If we want to go ahead and set that for a contested hearing, we can. In those case numbers, I know in speaking with Mr. Taylor, he wishes to advance his case as quickly as possible. I still want to engage in the discovery process, however. I have not formally filed a demand for speeding, because I'd like to get a hold as much as I can.
We've got this date and we got the 20th, but the 20th is already jammed up. And I'm not sure that's going to give you the time necessary to adequately and zealously represent your client. So we'll leave it on for 3/10. We'll analyze what we got in the trial week, and we'll look at what's going on. And if it looks like we got the time, then we can try the VOPs, because the state's entitled to do that, right?
Yes, sir.
If they wish to do that first.
Yes, sir.
But we'll just see where we are under those circumstances.
So the court is in the loop. I've met with Mr. Taylor at the jail, and I told him that I would file a bond motion and include those bond issues with the felony violations of probation, so the court would likely see him on the 20th.
Okay.
But I'd like this on the 10th and have all of his cases tracked together on that
They
pre-trial
will all
day.
track together on the 10th, so let's get them all grouped up, so let's be the most efficient we can about this.
Yes,
So-
Your Honor, and
And
I'll
then
get
we'll
that bond
analyze
motion
which
filed.
one we'll try, how we'll go forward with the trials on the VOPs versus the new law charge on
Yes,
the
Your Honor.
10th. Have you got your bond motion filed and set for the 20th?
Judge, I believe it is set to be filed. I know I've written it. I don't think it's on the docket as of yet, but I'll file it and have it set on the 20th.
Very good. All right, thank you very much. Thank you, Mr. Taylor. Good day.
Yes, sir.
Anthony Weaver.
Did you read that over? Right here. Judge, we've reached an agreement in Mr. Weaver's case. The state has filed an information in 25 CF 62. However, we're going to enter a plea for no contest to a lesser included offense. Madam Clerk, that is going to be to one count of petty theft, first degree misdemeanor, that is 8/12/14 sub 2 sub E. The agreement with the state is for an adjudication of guilt, time served, $270 in court costs, $150 cost of defense. May I approach with that misdemeanor plea agreement?
Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay. And you heard what Mr. McKinney said, you signed the written plea form?
Yes, sir.
You understand you're pleading no contest to the lesser included offense of petty theft, misdemeanor?
Yes, sir.
And you'll be adjudicated guilty and waiving your right to a trial. You
Yes, sir.
understand that? You'll be adjudicated guilty, sentenced to time served, to have the fees and costs that were announced. Is that right?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into, accept the plea. How much time do you think you need to get those fees and costs paid after your release?
Well, I'm fixing to file my tax, so just say 90 days.
All right, 90 days to pay. If you're making payments and you need more time, I'll give you an extension of that time, but if you're not making payments, I won't extend the time, you understand?
Correct.
Okay. Thank you very much. Step this way for your prints, please.
Thank you, McKinney, thank you.
Do we want to do the ones that were left over from this morning?
You're going to have somebody in the gallery, Tyler Merritt?
Tyler Merritt.
You got
Your Honor, this is Mr. Merritt. Alternative. I'll turn it over to Mr. Gomez, Your Honor.
Your Honor, at this time, the state is going to be announcing a null pros of 25 CF 000063. For count one, the reason for the null pros is a lack of sufficient evidence. For count two, the reason why we're null prosing is because Mr. Merritt was proactive, actually came in and showed me a valid driver's license that he had gotten. We want to make sure that we're encouraging that behavior, so for that reason, we're going to null process case, Your Honor.
All right, very well, case is null pros. Thank you, Mr.
All right, man, you good? That's it.
Judge, I have 3 left that showed up, if I may call them.
Go ahead, sir.
First call, Joe, last name Petit, who's present and approaching, 24 CF 2912, and that was Joe Petit. Yes, Your Honor. Receiving the formal charges, 4 counts, will be entering not guilty to each count and waive formal reading, and request to be kept on that March pretrial docket, Judge.
So ordered.
That's your copy.
Now, Mr. Petit, there's a form there for you to fill out that has all, he's done it?
Yeah, we've turned it in.
Okay, thank you very much.
See if we go. Please call, schedule that appointment. Okay. Next, Judge, if I may call Mr. Dexter Pearson, and that's 25 CF 47, and he's present and approaching, Your Honor.
Keep your hands on your pockets.
Yes, sir.
Stay right there. You're good. Pearson, Dexter Pearson. Now we need your contact. Thank you. Your Honor, this is the 25 CF 47 case. Receiving the information, will be entered not guilty to both counts, waive formal reading, requested to be kept on that March pretrial docket, Your Honor. And I do want to inform the court, my client also has a case on that 310 pretrial docket, and that case number is 24 CF 2852, Your Honor. We can keep them together.
All right, very good.
And my client did fill out the contact information, but I'll also give him my card, and you can please schedule an appointment for that next pretrial docket, okay?
Yes, sir, I'll do it.
Thank you now, good day.
Thank you. Lastly, Judge, if I may call Mr. Jonathan, last name Russell, 25 CF 34, and he's present and approaching. Thank you. Judge, receiving the formal charges in 25 CF 34 will be entered not guilty to 3 counts, waive formal reading, and request to be kept on that March pretrial docket. I also want to inform the court, my client has 2 other cases on that March docket, and that's 24 CF 893, 24 CF 914, Your Honor.
Yeah, and we had set those today for status as well, right?
Correct, Judge. This was during that snowstorm, we set it, and I did receive a global offer in all his cases, provided him a copy, and we're going to have some further discussions, Your Honor.
All right, very good. All right.
So you're free to go, but schedule that appointment with me before that March docket, okay? You're welcome. And that's all I have left present, Your Honor.
All right, who do we got left now? No, 130 docket, we're still on the 130 docket.
Do we have anybody on phone?
Yep, I think we do, don't we?
Yeah, some one leftover ones from this morning.
He said they were in the
I have
heat.
Rebecca Myers with no attorney.
Rebecca Myers. Rebecca Myers. All right, good afternoon. You're here today without an attorney. Do you wish to have an attorney represent you?
Yes, please.
Okay, have you completed the application for the appointment of an attorney?
No, sir.
All right, one will be given to you now. Complete
Okay.
it, turn it in. Don't leave until you turn it in and get a new court date, okay?
Okay.
All right. They'll give that form to you right now. Who else?
William, yes, William Reed with Mr. Koch.
William Reed.
Your Honor, my client was arrested this morning at 11 o'clock, so he is currently in custody at the Okaloosa County Jail.
Okay. Information filed on 124.
Your Honor, if I may enter not guilty on his behalf, keep that set for that March pretrial docket.
So ordered.
Thank you, Your Honor.
Yes.
Micah Walker. Micah Walker. State.
Request the KP's, Your Honor.
I have two cases, 25 CF 56, 25 CF 55. Issue a no bond capias, please.
Yes. Show a Daniel Sledge.
Daniel Sledge, please. Good afternoon, Daniel Sledge. You're here today without a lawyer. Do you wish to have a lawyer represent you in this case?
Yes, please.
Are you able to afford one on your own?
No.
Okay. Complete the application, turn it in to the bailiff. Don't leave until you turn it in and you do it a new court date, okay?
Okay.
All right?
Thank you.
Judge, is Mr. Michael Walker incarcerated?
Yes, I was just checking on that, he's downstairs in the holding cell. Okay. I'm having a ring on that. No idea why he's still there.
Well, okay. Don't issue the capias. Micah Walker, right?
Right, yes, sir. Micah Israel Walker.
Well, is he also on the 230 docket, or is he?
No, sir, I'm just showing him 130.
No, sir, just 130.
Okay.
Becker, you bring in most?
Keith Williams. Keith Williams. How about Mr. Williams?
Nine,
State.
Request for a KP's, Your Honor.
Issue capias.
No.
Misty Woodhams. All right. Good afternoon. You're here today without a lawyer. Do you want a lawyer to represent you in this case?
Yes, Your Honor.
You able to afford one on your own?
Yes, sir.
Okay. Take the form and fill it out. Pass it to a bailiff. Have you completed it already? All right. Give it to the bailiff and let me take a peek at it.
You may give it to you?
Mhm. All right, I'll appoint the public defender to represent you in this case.
This is Ms. Woodhams.
Yes, sir.
Has the information been filed in this case?
Yes, but it was filed this morning, so I didn't.
Okay. How many counts?
Let's see, count 1 is possession of controlled substance, and count 2 is drug paraphernalia.
We would acknowledge the receipt of the 2-count information, waive its formal reading, and enter a plea of not guilty. Madam Clerk, when is the next court date?
March 10th.
We'd like to keep it on the March 10th date.
All right. Now, have you completed one of the forms with your updated information, with your address, your phone number, email, and so on?
Yes,
They're
sir.
going to give you one of those right now because I don't see that.
Okay.
Now, fill that out and turn it back into the bailiff so that we'll be able to have that. That'll give your lawyer the information you need, and the clerk to be sure to give you the contact information, okay?
Okay, thank you.
All right, thank you. Michael Walker, please. Who else do you have? Did we do Mary Mason already?
So, we did, but I was looking at it, so it was just a bond. Dates and other cases.
Okay, all right. Let me know when we get back to that. All right, Michael Walker, you're here today without a lawyer. You want a lawyer to represent you?
Yes, Your
You
Honor.
able to afford a lawyer on your own?
No, no.
All right, I'll appoint the public defender to represent you. You're going to have to still complete the application. Take that with you to the jail, complete it, and turn it in, okay?
Okay.
Hold on, stay there.
Okay.
And we've got 2 cases, 25 CF 56, which is 1 count petty theft with a prior conviction, and then 25 CF 55, which is 1 count petty theft with a prior conviction.
37 days.
Judge, we would acknowledge the receipt of the information in each of those cases, enter a plea of not guilty, and ask for this to remain on the next scheduled court date. If we could have is it, Madam Clerk, is it March 10th?
Yes.
Okay, we'd like to keep it there.
All right, it'll remain on the docket for then. Now, complete that form and give it to the jail, and they'll turn it in for filing, okay?
Okay.
All right, thank you now. So, you run down the list of the stuff that we haven't finished.
Yes, sir. Rebecca Myers, we're waiting on PDAP.
Rebecca Myers, did you finish your PD application? Rebecca Myers?
And then same thing for Daniel Sledge.
Daniel Sledge, did you finish your PD application? And you got Mary Mason?
Yes, sir.
Your Honor, Ms. Mason was at court this morning. If we can just go ahead and enter a not guilty plea for Ms. Mason.
Not guilty plea is entered. What else do you have, Madam Clerk?
That is it on the 130.
Okay. So, Rebecca Myers, are you still here? Daniel Sledge? Okay, you still working on your application? Okay.
Your Honor, the 230, I have a plea that's in the feed.
All right. And who is that, Mr.
Mr. Barnett.
Clark?
Your Honor, this is Mr. Barnett. We're going to be entering a plea today to resolve these 3 violations, I'm sorry, 4. At this time, Mr. Barnett is going to be admitting the violations. The agreed-upon disposition is that Mr. Barnett is going to have a supervision revoked and terminated. He will be sentenced to 29.55 months in the Department of Corrections. The state will stipulate that Mr. Barnett has previously served 24 months in prison previously. He's also been in the Okaloosa County Jail for 4 months at this point, so he's essentially served 28 months of the 29.55. He would be assessed a $100 cost of prosecution for each one of these cases, 1 $50 application fee, 4 $100 public defender fees. He's previously been adjudicated. May I approach?
Granted.
And if I didn't announce it, Your Honor, in addition to the state stipulation, there would be credit for any other time served.
All right. And is that the state's agreement?
That's correct, Your Honor.
All right.
So for the credit, am I putting 28 months credit, or am I doing credit for time served including 28 months?
I would probably best word it as state stipulates that he has served 24 months prior prison credit in addition to any other credit he's legally entitled to.
State would agree. Because he was in DOC, so we're stipulating his DOC time and then whatever time he's legally entitled to for being held on this case.
Okay. So the sentence is 29.55.
Correct.
The state agrees that he has 24 months of credit. And it's unknown if he has any other credit, but the state agrees he's entitled to any other credit he may legally be entitled to.
Correct, Your Honor.
To fill in the blanks there, Your Honor, Mr. Barnett has been in the Okaloosa County Jail on these violations since the middle of October of 2024, so that credit would also apply.
Right, okay. So the 24 months you're talking about is prior prison credit, which the state understands he has, but we're not able to say at this time specifically what other credit might be available.
Correct, Your Honor.
Correct.
Okay.
And
All right.
I was just advising Mr. Barnett, when I see the jail, I will keep an eye out because of the credit situation with his cases. I will make a point to keep an eye out for the credit worksheet from the jail to check that.
All right, so raise your right hand for me, please, Mr. Barnett. Do you swear affirm, testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand down. You heard what Mr. Klein said and you signed the written plea form.
Yes, sir.
All right. Now, in this case, you've got violations of probation on all these cases, right?
Yes, sir.
And this plea says that you're admitting those violations.
Yes, sir.
And by admitting those violations, what I understand you to say is that you violated your probation just the way the affidavit report by your probation officer says you did.
Yes, sir.
You understand by making this admission, you're waiving your right to a hearing where the state would have to prove your violations.
Yes, sir.
You've been previously adjudicated guilty of these charges, and your sentence here is a revoke and terminate your supervision with the fees and costs that were announced, plus any outstanding financials that you have.
Yes, sir.
And you're sentenced to the 29.55 months in the Department of Corrections with the agreement that you've served 24 months in the Department of Corrections, plus you're entitled to any other credit that you may lawfully be entitled to based upon where you've been in jail for now or maybe any other credit. But we don't know what that might be, and that's the reason it's being announced that way.
Yes, sir.
Okay? Once you're released from incarceration, how much time do you think you'll need to get all your fees and costs paid? Because they're substantial from my review of your cases.
I've been incarcerated for 6 years right now. I'm not certain, sir. I mean, I
Do you
plan on
think
having a job
36 months would be sufficient?
Yes,
Okay, I'll give you 36 months to pay after release. And if you're making payments, then I'll extend that period of time, as long as you're making payments. If you're not making payments, I won't give you any more time. But if you're making payments, the goal here is to get the things paid.
Yes, sir.
All right. All right, I'll find the plea to be freely and voluntarily entered into and accept the plea.
Madam Clerk, do I have anything else on the docket?
I show 12 cases, Mr. President.
Yes. Okay, I don't have anything else, Your Honor. May I please be excused?
Yes, sir.
Thank you.
Mr. Durrell, are you ready with your case?
I believe we are, Your Honor.
Okay.
If may it please the court, Dustin Durrell on behalf of Mr. Michael Walters. And Your Honor, may we approach briefly on Mr. Walters?
You may.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
All right. And so, didn't I see Mr. Henderson?
I'll go check the hallway.
Okay.
He wasn't in the hallway, Judge.
All right, so, Mr. Koch, what about Elisa Peterson?
Your Honor, Mr. Koch just showed me, so our whole thing with this case has just been getting the restitution paid, and it's been, for lack of better words, a hassle to do this. There is I have seen proof that $2,000 has been paid. There's a $500 more that we want, that we agreed with Mr. Koch. If she paid $2,500 of the $5,000 that was owed, we would dismiss the VOP, revoke and terminate, and then terminate probation. And speaking with Mr. Koch, she has about $500 that are owed. So what we would like to do is set this for, I believe it is the April 17th miscellaneous date with subpoenas, with the idea being that either she pays that $500 or we are going to have an evidentiary hearing on that 17th date. So the idea, we will resolve this case on the April 17th, but we want to give her an opportunity to pay that amount, and if she does, we will dismiss the VOP, or terminate probation before that April date.
Okay. You agree, Mr. Koch?
Yes, Judge.
All right, so it's a VOP evidentiary with subpoenas on the 17th at 2:30.
Yes, Judge.
Thank you, Judge.
Thank you.
Thank you.
And then, Your Honor, if I may, just because I know the attorney that's here for Mr. Mitkovicius isn't necessarily aware with this courtroom procedure, but it's with Luis Morioki.
Yes, yes.
And it'll be quick. The state has an announcement that will get Mr. Morioki off the docket, Your Honor.
I apologize, I didn't see you come in. Thank you.
No worries.
All right.
Your Honor, at this time, based on a lack of sufficient evidence, the state is going to be announcing a null pros of 24 CF 1956. That new law case was the basis for the violation of probation in 23 CF 1701. Given the state's null pros of 24 CF 1956, we would be dismissing the VOP in 23 CF 1701. He would be reinstated back on to probation to complete the original terms that have been set forth, but the VOP would be dismissed and that new law would be dismissed as well.
All right, thank you very much. Just chat with probation before you leave. They have a notice to give you and an explanation of what you need to do. And I'm sorry, what was your name? I'm sorry, I apologize.
Whitney Ponson, Ponson.
That's right. Thank you very much.
I'm sorry, Your Honor, I couldn't hear because I was talking to Mr. Snell.
Okay.
The state null pros, the new criminal charge, and as a result, that's the only basis of the violation, so they've dismissed the violation and he's restored to supervision, same terms and
Well,
conditions.
that terminated in, is this Lewis?
Louis?
Morioki?
Okay, that turned in 2024.
Okay, well, we'll go ahead and terminate his probation, Your Honor. Any
All right.
outstanding monetary obligations will be converted to a civil lien.
Yeah, okay.
Okay, all right, thank you.
Thank you.
Is it just terminated or terminated and revoked or just?
No, just terminated because, yeah, we dismissed the VOP, so just terminated.
All right, so that leaves Mr. Durrell.
Thank you, Your Honor. Yes, Your Honor. Pursuant to discussions with the state, and I've gone over that with my client, we would be requesting a continuance of this matter until March 13th.
Matter will be continued to March 13th.
Is that a morning docket or afternoon, Your Honor?
We'll put that on,
Said March 13th?
Yes, please.
what's that?
That is not.
Oh, you don't have that date?
It's a pretrial detention docket and felony plea day. Are you needing a miscellaneous date?
Well, let's go ahead and put it on there for its take. We'll put it on for the plea day for a change of plea because of the special circumstance.
The only problem is the system will only pull felony plea day cases onto the docket.
Okay.
So if I set it, it won't be able to.
Okay. So what that happens, say again?
What about the 12th?
Yeah, put it on the 12:30. We'll put it on the 12:30 docket.
12:30?
Mhm.
On the 13th, Your Honor?
Yes.
Thank you.
It's just a special situation that and I'm trying to accommodate your circumstance.
I appreciate that, Your Honor. Thank you
Okay.
very much.
All right, you're welcome.
All right, and I believe that's all
All
we
right,
have.
thank you. That
Thank you.
leaves us
Thank you.
with, I guess we've got Mr. Sledge, right? And we got his application.
I do not, yes, sir.
Say again?
I do not.
All right, and did we get Rebecca Myers with her application? Okay. All right, and who posted your bond for you, Mr. Sledge? Did you do that or family?
My father.
Okay. All right, I'll find that you do qualify. I'll appoint the public defender to represent you. The clerk will review your application. If they say you don't qualify, they'll tell you why. If you think they're wrong, get everything that shows you think they're wrong, give it to your lawyer, and bring it with you to court next time, okay?
Okay.
And here we have a 3-count information, DUI, POP, and POCS.
Yes, Your Honor, we'll be entering a not guilty, waive formal reading, and request be kept on the March pretrial docket.
All right. Now, stay in touch with your lawyer, and the only way they can help you is if you stay in touch with them and give them information they need, and then be back in court on 310, okay?
Okay.
All right. Rebecca Myers?
Appreciate it.
Yep.
All right. I'll find that you do qualify. I'll appoint the public defender to represent you in this case, and as you heard, the clerk will review your application. If they say you don't qualify, they'll tell you why. If you think they're wrong, get everything you show that they're wrong and give it to your lawyer and bring it to court with you next time, okay?
Okay.
All right?
Did Mr. Clark?
And here we have, Mr. McKinney, we've got a 2-count information, POCS and POP.
On the clerk of courts, it was saying May, but.
Judge, we'll waive formal reading in our plea of not guilty. Is that already on the May docket for pretrial?
Yes.
I'd like to leave it there for Mr. Klein's.
Okay.
Okay, awesome, thank you.
Make sure you contact
Thank you.
Did we get everybody on the 130?
Yes, sir.
Okay. And everybody but Mr. Henderson on the 230.
Yes.
Here comes Mr. Henderson now.
Good afternoon, Judge.
Good afternoon, Mr. Henderson. Michael Gilbert.
Yes.
Judge, may I need a state approach on that?
Granted.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
And I'll leave this on so you can explain to your client what's going on, Mr. Henderson.
Yes, Your Honor.
Mr. Henderson. All right.
Judge, pursuant to negotiations with the state, this state of Florida versus Michael Gilbert, Tony Henderson for Mr. Gilbert, we're entering an agreement where it calls for an admission to the violation of probation. He'd be adjudicated guilty, assessed VOP costs. He'd be reinstated to the conditions prior with GPS. I'd ask that the court maintain the GPS amount of $1 a day. The GPS is to be attached before release. Added sanctions of 30 days Okaloosa County Jail, and which he would get credit for the time that he served. I believe he's already served that amount. Followed by 6 months of community control sanctions, 2 annual home searches a year by probation, and forfeit photos to be destroyed by probation. Also, he's to complete all original requirements.
All right, that's the state's agreement?
It is, Judge, and it is a downward departure based on negotiated plea.
All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, you can put your hand down. You heard what Mr. Henderson said on your behalf, and you signed the written plea agreement?
Yes.
All right. Do you understand by this plea arrangement that you're admitting the violations in this case?
I do.
And by admitting the violations, what I understand you to say is that you agree that you violated your probation just as the affidavit and report filed by your probation officer says you did.
Correct.
In this case, you've also understand that by making this plea, you're waiving your right to a hearing where the state would have to prove your violation.
Correct.
And your agreement regarding the sentence on this violation is you'll have the VOP costs, which would be $100 cost of prosecution. You'll be reinstated to your conditions and must complete all your original requirements. Then you'll have the 30 days in the county jail with credit for your time served. After you complete the county jail sentence, you'll be on 6 months of community control sanctions. You'll have the GPS attached before your release. Then you'll have the additional provisions of the 2 annual home searches by probation. And the photographs involved will be forfeited and destroyed by probation. That's in addition to all the previous terms and conditions which existed and all the standard conditions of probation. Do you understand?
Yes.
Is that your plea?
Yes.
All right. Mr. Henderson answered all your questions about the plea and how it affects you?
Yes, he did.
And you're satisfied with what he's done for you?
Yes.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Now, I believe the state's saying you have that 30 days credit, right?
Yes, Judge.
Now, the only issue will be, considering the time of day, probation may not be in a position to get to the jail and attach your GPS today for your release, so you can't get out until the GPS is attached. Do you understand?
Yes.
And once that's done, you'll still have to report to probation, so before you leave the courtroom today, they're going to give you a notice about that, in addition to saying that they'll come and attach the GPS before your release. Any questions?
No.
Okay. Thank you very much. Thank you, Mr. Henderson.
Thank you, Judge. That's all I have.
Yes, $1. Thank you. $1 per day on the GPS.
Thank you.
All right. Mr. McKinney, you have something else, or? Okay. Anything else? Madam Clerk, we get everybody?
Judge, may I vote with the state?
Yes.